24. What do you want? Huh? Who appears for respondents? They don't have an objection. No notice issued. Whom have you informed? Tell him.
There is a state
Interim.
matter.
You do it with a pinch of salt when there is an interim order, right? Let it be called. We are sure that 24 and 25 will be called.
My lord, item 26. Item 26, my lord, appearing for the respondent number 2. Your lordship may kindly grant me 1 week. Inform the petitioner they have no objection. Item 26, my lord.
Interim order.
26,
You are
appearing
respondent.
respondent, my lord.
Lordship, I have it on Monday, Lordship, for the appellate.
We don't know how it is placed. Monday. Please see. All right, 18.8.
Obliged, my lord.
Learned counsel for respondent.
2, my lord. Respondent 2.
26, right? Madam?
Yes.
But it's his appeal. Why should you seek adjournment? He has to make out a case for admission.
There's a personal inconvenience, my lord, for
No,
counsel.
but he has to argue, right? We won't ask you to argue.
Counsel for
Learned
respondent.
counsel for respondent number 2. Praise for adjournment on the ground that the arguing counsel, Mr. So-and-so, is not available. List on 18.8.
Obliged, my lord.
Yes.
Page number 3, item number 20, next to item number 44.
Yes.
Page item number 42, item number 60. Page number 5, item number 2, and
Yes.
Lordship, I am representing Avane Reddy Lordship.
Huh?
I am for the petitioner Lordship, Avane Reddy Lordship, Senior Counsel President Lordship, O Manohar Reddy.
68.
68, item number 68 Lordship.
When the case is called, this is hearing matter, Mr. Why get an
Represent inconvenience Lordship,
No.
Senior Counsel Monday Lordship.
No Monday. This is 21 writ petition listed for hearing. You are seeking adjournment. We are not at all in a hurry to decide 21 matters. Very good. It will come after 2 weeks. Learned counsel for the petitioner 68. What's your name?
they are all connected. 68.
Sri Karunakar Community Lordship.
So what is the subject matter? What is the subject matter of these petitions? We don't know.
The
This is
requested
the
law.
advantage you take right at 10:30. We don't know. The file is not there. You also don't know. What is the subject matter? Is there a stay operating?
The requested Lordship.
Please wait then. If you don't know what is the case about, if you don't know whether there is a stay in your favor, then please wait. He has inconvenience. This prayer can be made when the case is called. You have no inconvenience. You will be in the court till 4:30, correct? Then
Plus.
don't find out. Mister, in case there is no interim order, then we will adjourn it. In case there is no interim order, what is the petition about? You tell at least anybody.
I got the respondent.
What is the matter?
Matter, my lord, they have procured degrees, my lord, from they have procured degrees, my lord, from distance education, my lord. Based on that, my lord, that
And they are on
Promotion
the
was-
basis of interim order. They
there
are
is no
providing-
interim order. There is no
No
interim
interim
order.
order.
No.
This is that law degree.
Yes, not law degree. They're Genco, my lord,
Oh, okay.
engineering.
So there is no interim order.
There's no interim.
All right, then fine, mister. That you must know before making a prayer. 68 to 70, learned counsel for the appellant. What's your name?
Sri Karunakar Community Lordship.
Prays for adjournment on the ground that the arguing counsel is unavailable, is not available on account of personal difficulty. He therefore prays for adjournment, list after 3 weeks. Yes, that's it. Now it's over. What,
Your lord,
out of list? Yes,
your lordships.
please, out of list.
The writ petition is filed challenging the unilateral appointment of arbitrator by SBI Card Payments Limited.
What payment, see?
Challenging
What
the
payment? Urgency?
yes, my lord, the arbitrator is
What? No, urgency. What is the urgency? You want it listing tomorrow, right?
my lords. Your
What is
lords,
the urgency?
the arbitrator is proceeding with the matter tomorrow.
What is the next date?
My lord, tomorrow he is proceeding with the matter.
No, is it commencing, arbitrator is commencing or passing an award tomorrow?
He has issued a notice for hearing.
Much water has to flow.
Nothing will
Between
happen.
the commencement
It
and award.
can come up next week, right? 18th August.
WP 11214 of 2023 presented today with the
Huh?
WP 11214 of 2023 with that. Posted today when.
No, it must not be of this roster. We are sure. No, this roster.
I.
Which subject matter?
It is allocation of judicial employees in the subordinate post.
Must be some other date, because what happens, people appear in bench and say, link it that with the petition, that petition. So it must have, your case must have gone. Meet registrar judicial. Meet registrar judicial. He will inform you what is the date. Right?
Your Lordship, with the client permission. Your Lordship, there is a CA commercial court appeal on. It was last listed on in the June. We have an IM for stay in that matter. Kindly, this CA may be listed for the Lordship.
Mention memo. What is for hearing? Final hearing? No.
No, yeah, it was in the admission side, and we have also an IA for stay of the proceedings. We are the appellant.
For IA for stay.
By the order of the Honorable Commercial Court, judge have filed this appeal, in order 39.
18-8.
Your Lordship,
TPO.
writ appeal number 1614 of 2000.
You are party in person
Yes, Your Lordship.
permitted by the committee? Yes.
Your Lordship, writ appeal number 1614 of 2017. Honorable ex-Chief Justice was pleased to post it on 14th of July this last month. But due to his elevation and farewell, it did not come up. So, Your Lordship,
You give it to registrar judicial. He will look into the matter.
Lordship, please.
Why do you want its listing for what purpose? It will not come up for final hearing. If any interlocutory application is pending, then
For hearing only it is to become.
final hearing.
Yes, Your Lordship.
Then please file an application for early hearing. Please file an application for early hearing and then seek a memo. We will decide. We will fix a date then.
It was already fixed on 14th July, Your Lordship.
We are bound by rules of procedure. What rule applies to everybody will apply to party in person else.
Senior citizens of
That's why
52 of age, Your Lordship.
this young man will help you in drafting the application for early hearing. Please help him so that his application for early hearing can be filed today. So we take up or orders on that. Explain to him that by way of mention memo, we don't grant final hearing. Yes.
Your Lordship, permission, Milord. Milord, I move the lunch motion, Milord, the people feel, Milord, first, I filed yesterday, Milord, it is the agency that, Milord, today they are conducting the action, Milord, regarding the goodwill land, Milord.
Who are you?
Milord, I am an advocate, Milord. Advocate is the petitioner, Milord.
Advocate petitioner. So what are the urgency?
Urgency that, Milord, today they are going to conduct the, Milord, the land which was earlier, Milord, the Honorable Court is asked to allow the High Court purpose, Milord.
Have you taken into this thing? You a member of this bar association,
Yes.
or you are from some other state?
No, they are member of this association, Milord.
Member of bar association.
Yes.
Have you spoken to your colleagues at the bar? They have met us and this thing, are you aware?
Yes, I know that, Milord. But one way,
By this PIL, you don't want that the land should be allotted, right?
no,
This is
for allotment.
No, please, Mr. Talk to your president first.
Yes.
President and executive members, they have met us. Please talk to them and then decide to make a mention. We will definitely take a call. If a litigant comes before us, it has to be heard. But it is in the interest of institution, we are telling you that please talk to your president and others. He has come to us, he has met us. I have met everyone, including Advocate General and Chairman of Bar Council and your president.
Milord, it is a
I cannot disclose sitting here what has transpired, but you ask him and then make a mention. Make a mention. We believe that all of us, I firmly believe that all of us are working in the interest of the institution, including you.
There is a difference
Please
of
talk
opinion in this case.
So therefore,
Yes, there is a difference
All
of
of-
opinion.
Mr.
Among the
you are experienced enough to understand. We don't want to say so many things. We can't say so many things. You should understand. In case your intention is to stall the whole process, file petitions, do everything whatever you want. In case you want to stall this thing, in case if anybody has set you up who wants that this court should continue here only, please, before that, we have to hear if any petition is filed. But please, since it's a matter pertaining to this institution, that's why this unusual stand-up. Otherwise, ordinary litigant, we would have said today, tomorrow, whatever.
Yes.
Today at 1 o'clock, we could have easily said. But why we are seeing, please, there is always in a joint family, there is difference of opinion. Gentlemen negotiate their differences of opinion and arrive at a consensus. We are not saying that you are not justified in having a difference of opinion, but please speak to your president and executive members, then do it. Right?
Your Lordship,
We have to hear the case. We cannot say that we won't hear, right? But you first talk to them and let there be a consensus. Please speak to them.
Yes.
Your Lordship, stand permission. It's a petition in a writ appeal of 2021. Your Lordship. There is a stay on a
Next week,
So there is a stay on a construction.
18th August.
Your Lordship, WP 21586 of 2023. 21586 of 2023, Your Lordship. I need to move lunch motion in this matter, Your Lordship.
JNC.
Petitioner is a NEET qualified medical aspirant, Your Lordship, who has been declared ineligible for the counseling.
Counseling when it is.
Web options are expected to be on Saturday, on this Saturday, Your Lordship.
Then tomorrow.
Your Lordship, I need to move a lunch motion, Your Lordship.
Tomorrow, you said that web option will be on Saturday, right?
Yes.
So we will hear you on Friday.
It's posted tomorrow, actually. Your
Tomorrow. Yes.
Appeal of
1 second, counsel. Have you filed an application because it's a already registered matter? It's not a fresh matter. Have you filed an IA?
Yes, we have filed an IA.
What is the IA number? Tell us the IA number now. Saying that this is the urgency for moving. Lunch motion.
Yes, Your Lordship.
So where is that IA?
No, no,
The
Mr.
pending matter, it's
Yes.
already a pending.
No, no, see, we act under the bona fide impression that all these, what you are saying are fresh matters. Huh? This you should, like brother pointed out, you should have been fair enough to say that this petition was already filed, notices have been issued. Now I filed an IA, say seeking interim relief and I want its listing. Supposing if in your case court has given a date of 16/8 and you want it to be heard tomorrow, do you think that we will, when the case is called up, we will not see the previous order sheet? And then you will be in trouble. The case will not be taken up. What is the next date of hearing? Do you know? Don't waste time, mister. It's precious. Time of this court is precious. Don't waste time. And be fair all the times. This we are repeatedly telling the bar. You owe a duty to be fair to the court all the times. This is what fairness demanded from you. You have failed.
Writ appeal of the year 2018.
Final hearing.
No, interlocutory stage, it is.
What IA? Vacating.
No, I am vacating the interim order.
You have filed.
Yes, Your Honor. State
When?
filed the appeal,
When have you filed this application?
21 itself,
21st July?
21.
2021.
2021, not come up for hearing.
Yes.
What is
You
the
have
IA?
waited patiently for 2 years, right?
Well,
And today.
any date will not.
Auspicious date. Sir.
Saturday, we can.
19th August.
19th August is a working Saturday, so we are giving you 19th August.
Public.
Your worship, public interest litigation, constructions are being made in the FTL time.
Hey, it is already pending, right?
It's another
Another time.
No, no.
So another pill, you are a public interest litigation expert dealing with water bodies, right? Saturday.
Saturday, 19th.
Fresh matter, no?
fresh matter.
Saturday. No, fresh, then why are you mentioning? It will come automatically next day, tomorrow it will come.
They said that.
You don't want today, right?
No, tomorrow.
Tomorrow it will come, no? That let us, we have been told that fresh filing come the next day until unless there are office objections.
Something I want to bring to your lordship notice. After scrutinizing, they are sending to the registered judicial who has to confirm. That's why it is taking lot of time. It was the earlier practice of this honorable court is being done.
Registered bills.
Public interest litigation, they are examined, no, by at the first instance.
If it come tomorrow, good.
Mr. Naresh Reddy.
Position is
Monday.
that if they file
That
today,
will be day.
it will come today, no? Tomorrow,
Allow them to put more bricks.
so it will come tomorrow.
Be satisfied for.
It will come tomorrow.
Past experience.
And if not in order, then you are. So on on compliance with office objection, it is listed next day. All right, this is the position.
Your lordship, this is fresh application, writ appeal, lunch motion lordship. There is a threat of
Urgency.
disposing us. There is a threat of disposing us by issuing new Patadar passbooks, even though I have my Patadar passbooks. Kindly allow for the lunch motion, my lord.
Tomorrow.
Tomorrow there is a meeting with collector. Kindly allow today.
Tomorrow it will come. Nothing will happen.
Lunch motion for today, my lord.
Before the court.
You tell the collector that the matter is listed tomorrow.
No, same thing we informed, even though he is in a hurry, kindly allow for today.
No, where is he? Has he given notice that you will be dispossessed today? What basis you are saying that you will be dispossessed today afternoon
Tomorrow,
at 2 p.m.?
every week they are
1:30.
giving notice to us to appear on Friday or Saturday. As tomorrow is the day after
So we
tomorrow is
assure
written
you-
Saturday. They have given for tomorrow only. There is a urgency.
1 second. When was the notice given to you?
No, what last month, my lord.
What were you doing all these days? Come at the last moment. We said that is the reason I said tomorrow.
Yes, tomorrow.
My lord, subject to your lordship and permission, my lord.
Much
I may be permitted to move a lunch motion, my lord.
Nobody says I may be permitted to withdraw. We look to everybody
I may be permitted.
who wants to withdraw.
No, my lord, I may be permitted to move a lunch motion, my lord.
Why?
My lord, there is an urgency, my lord, the petitioner.
That's why. But what urgency
My lord,
like him?
my lord,
When did you file an application or petition?
It's a fresh writ petition, my lord.
Fresh.
Petitioner
When
is-
did you file the petition?
my lord, now we after obtaining the permission, my lord.
After we give permission.
How in this case? So first,
Computer center.
And she said,
My lord, petitioner is a student, my lord. He's seeking
that's
admission.
fine. But the only thing is, have you filed the petition?
My lord, now we are filing, my lord.
Then can you, this thing mention memo in anticipation of a petition? What happens if it is not filed?
My lord, now, my lord, already.
Please file and then come. Please file the petition.
Simple thing,
This is-
instead of wasting 20 minutes here, you should have filed and got the SR number.
My lord, already my
Then you should have got it in the
Tomorrow
message.
Take steps to get it numbered by 1:30, it will come automatically tomorrow.
My lord, I may permitted to, my lord, mention, my lord, after it being.
You first file and then mention, then we will decide what is to be done. But we cannot permit mentioning in a matter which is yet to be filed. This is
Bless,
clear.
my lord.
Subject to lordship's pleasure, my lord. There is one contempt in which there is a direction. Your lordship may please to take up this matter next week, my lord. You do this.
No, this all over. You don't want us to begin with the list, right?
I'm last person waiting for my turn to come, my lord.
What you mentioned.
Yes, I'm making a mention, my
Out of list.
out of list. I'm
Okay,
making.
so we thought that you are mentioning something about the adjournment from 2005 matter.
I'm seeking your lordship permission to make a mention, my lord. There is one matter in the contempt, there was a direction. Not to hold election for cooperative society for past 5 years, we couldn't.
Urgency, Mr. We are not interested in subject matter. Urgency. What is the urgency? What will happen
Because of this
if
take,
tomorrow or at 1 o'clock it is not heard?
my lord, it may be taken up even next week, my lord.
Date.
Yes, any
Say
day.
so. Say so that any date it may be fixed.
Next week,
Or
any
it's for admission or for final hearing.
final hearing.
Final hearing doesn't come by, make an application for early hearing, then move a memo for listing of that early hearing, we will fix a date. Mention memo is never moved for final hearing of a matter. That's what we have told the party in person and everybody. Yes. Yes, ma'am.
These writ appeals are devoid of merit and are dismissed, no order has to pass.
Much obliged, lord.
All madam.
Yes.
It is your lordship for the appellant in this matter.
Kind indulgence before my friend could start. If my lord's papers were just served on us, my lord, if your lordship so pleases kindly accommodate to tomorrow, my lord. Because they were served on the other department, their papers are passed on to me, my lord, just now, my lord.
My lord, there is even a connected writ appeal with this matter with the file together, but one was returned with some objections. Even that may be posted to next Wednesday, my lord.
So he has to be heard, madam. It is for admission. Why?
No, I'm just bringing.
My lord, there is a delay.
No,
Yes.
it's a fresh matter for admission.
Yes.
You want to argue before him?
No, I'm just
Sit down,
bringing.
please.
I'm just bringing your lordship's notice, my lord. Papers were just passed on to me, my lord.
No, this. But we have to hear him on admission first. This is nothing.
My lord, there is a delay of 79 days in this matter, my lord. A condoned delay petition has been filed in this matter. So, and there's a connected writ petition also which has to be connected. Writ appeal, my lord. Apologies, my lord.
Writ appeal. Number?
SR number 30042.
30.
042. 30042.
Of
23, ma'am. This is the SR number, ma'am.
It is not yet numbered.
Not yet numbered. No. We filed both together, my lord. One was numbered and one was not numbered. Yes.
What do you say condonation delay, madam?
Well, I'll file my objections for that, my lord.
Condone delay.
What condone delay? You don't file appeals along with application for condonation of delay?
We do, my lord, we do.
And will he oppose your application for condonation of delay? Looking to his, you know him, will he oppose?
I'll leave to lodge. I'm sorry.
No, madam, I want to take this opportunity to share with you that I was a young judge. I had put in about 2 years of judgeship. I condoned the delay of 10 years and that order was upheld by Supreme Court also. Thereafter, I don't know, anybody who knows me doesn't argue or oppose. All we will have to do is to add 3 more paragraphs to an order which is already, but we are sure that you will not permit us the time. You will appreciate that the time of this court is precious. And for unproductive things, we should decide the appeal on merits one way. And he has to he knows what is the difficulty, but you are helping him by seeking adjournment. For what reason, we don't know. What reason you have not filed a caveat, right? You are on an advance notice. It is his appeal. We have to hear him on admission. It's a strange thing that counsel appearing on advance notice seeks adjournment for what? The very purpose of the advance notice is not enable you to seek adjournment.
My lord, that notice I have not received, my lord. That is my grievance.
Then don't appear. We will do whatever he is appearing. We will decide him. This, madam, again we are telling you, this whole time is precious.
Very, very well.
Whatever. If any order is passed which is adverse to your interest, remedy of appeal is there. But you cannot stand up in a matter where there is no this thing, the notice has not been issued, and seek adjournment. If we may ask you on what ground you are seeking adjournment, what will you tell us? So if we ask you, we understand that you are seeking adjournment. Supposing if this court asks on what ground, what is your answer? Please tell us.
Only, my lord, to assist your lordships in a proper perspective, my lord, I sought an adjournment before.
No, but we are not seeking your assistance. The admission, in my opinion, is a matter between the appellant and the court prima facie. And if your assistance is required, we will seek your assistance.
Yes, very well.
He has to argue.
Yes.
Don't seek, madam, adjournment.
Very well. Hereinafter, I'll be careful.
No, after notice matter where you want to file counter, you should immediately stand up and say that respondents 1 and 2 and 3 weeks counter. That you should do.
Yes.
But not in a fresh admission matter where he has to be heard.
Very well, ma'am.
He was about to argue. Yes. Now.
My lord, I may argue today, my lord, but there's a connected writ appeal also which we have heard together with this writ appeal.
But this is not numbered. This is what is along
filed together, my lord, but it was returned and we have resubmitted the matter to him.
This is not coming in this. When we should tell this AC, they should shift, not coming. We will say WPSR. WASR. Learned counsel for the appellant prays for submits that this appeal be heard and all.
Right. I can move AV grounds.
But I may be permitted to appear in this appeal for the appellant.
But in this matter,
It's only a short question.
I'm appearing for the respondents, my lord. Before the senior counsel begins, my lord, in this matter, my lord.
My friend has not heard your lordship with regard to the previous matter and what your lordships have said with
Fresh admission.
Yes, my lord.
Caveat file.
No, my lord.
That's the thing.
My lord, this respondent.
That's why I said he has not heard your.
You should feel happy that they are conceding that you have a case. Yeah, so at least, I mean, we have to satisfy whether or not you have a case for admission, but they have considered that the matter involved in this appeal requires consideration. That's why he's seeking adjournment.
Right, tomorrow, not much.
Why you are seeking adjournment?
Not because the senior.
Is it your, no, is it your appeal?
No, not their appeal.
No?
I'm appearing for the
So
respondent.
say yes or no. Your appeal?
No.
Have you filed a caveat?
No.
That?
Because
how you are appearing? Same question which we asked to madam. How you are appearing? What authority?
Not because our name is being reflected in the cause list.
That is advance notice.
Yes, madam.
What can be done?
Because due to some inconvenience, senior counsel is not attending the courts today, my lord. It may be taken up tomorrow.
May I begin?
No. So, Mr. What status quo order has been granted for 4 weeks? That has expired.
That has been subsequently extended. I'll just.
Where is that order?
Filed it. Those orders have been filed, my lord.
No, but have you challenged those orders in this appeal?
My lord, all that has been challenged, my lord.
Where is that prayer clause? Show us.
And the original order, what I'm trying to submit to your lord. Yes.
So therefore, you will have to amend do whatever, Mr. See the prayer clause you have challenged 6/6/23. 6/6/23 has expired.
Yes.
And why can't you move learned single judge seeking vacation?
No, I've done that several times. My lord, I'm just trying to, I've done that several times.
So we will request when did you file an application seeking vacation of stay?
My lords, I filed the vacate also before his lordship.
When?
My lord's lordship may see on 9/7/23, which is at page 90 to 98.
We will request the learned
only
single
on the
judge. No, we will request the learned single judge to decide your application for this vacate.
Well, just
petition.
before that, I'll just make a small submission with regard.
No, Mr. Senior Counsel, the legal position.
I know.
After half an hour, we will arrive at the same conclusion. We appreciate that you note the importance of
In fact,
time of this court.
twice we.
Interim order, you want us to say we will not entertain ordinarily. The order is not without jurisdiction. Court has power to direct grant of status quo. It's not your case that the court has no jurisdiction to pass an order.
That's my case. That's my case.
No jurisdiction.
No jurisdiction. That's why I've come to this honorable court. I'm fully aware, my lords, of the, if I may.
No, Article 226, court cannot grant an order
that's
directing parties to maintain.
I am saying that, my lords may allow me for a moment, my lord.
Mayor.
Yeah.
You see, there is no point. This is an interlocutory order.
Yes.
Matter is pending because in a writ appeal, we adjudicate anything. Then the writ petition becomes infructuous without before writ petition. Let's say we hold something in this in the writ appeal, which is filed against an interlocutory order. That
You
will
sit down.
affect the interest
Sit
of the
down.
parties. So
why I'm saying
that view. What,
yes.
Of the view, at least
Yes.
speaking for myself.
Yes,
I would
we
say
will not.
better to move the learned single judge, and if you have seen
We request the learned single judge to move. Thereafter, you can always file an intra-court appeal.
Why I'm saying there's no, my lord, just 1 minute, my lord, just half minute. Why I'm saying there's no jurisdiction in this matter is private respondent in an earlier writ petition suffers an order. This honorable court directs GHMC to do something, my lord. That private respondent, instead of filing a vacate in that earlier writ petition, moves another writ petition on the action of the GHMC and seeks a status quo with regard to that order, instead of filing a vacate in that earlier order. So, my lords, there are therefore, lordships grants status quo without hearing that earlier matter in which a vacate has not been filed.
That's why I'm saying if these things can be told to the learned single judge, I'm sure you will also appreciate.
Earlier.
Order of 6/6 is status quo for 4 weeks. That period has expired on 6/8. 23. Other orders not yet. So this period of status quo was BPSC has moved. All right.
In fact, my lord, what has happened is earlier the private respondent is there in the earlier.
The problem is you are arguing on merits. We are at the preliminary stage. We may have an excellent case.
Yes, yes.
But all this argument should be made before learned single judge. That's the only thing we are saying.
In fact, I
We
made
may
it.
have an excellent case.
Yes,
Fine.
madam. All I'm
Right, anything
submitting
else?
is, all I'm submitting is a private
We
response.
will request the learned single judge to decide your vacate petition in a week.
In a week's time, please tell us the number, IA number.
Yes, yes.
Which
I have
is-
filed it at page 90,
Yes, madam.
9 to,
No,
90
IA
to
number. IA number.
IA number in the vacate, my lords.
Mark the presence learned senior counsel for the appellant in this intra-court appeal. Don't mark his presence. In this intra-court appeal, the appellant has assailed the
Why the appeal was filed was an issue of jurisdiction was thought to be raised by
that
me.
you can raise no before learned single judge.
Yes, but
See, mister, what
Yes.
happens is that you may have an excellent case, but it's a question of setting up precedent. Like if we start entertaining, supposing learned single judge would have directed something drastic against you, that you be taken to islands of Sri Lanka, then we would have entertained.
Yes, yes.
It's nothing like that.
yes, Andamans.
And then we would have stayed intervened. But see, you will appreciate
Yes.
that we have to, like, ordinarily we will not entertain an intra-court appeal against an interim order. You are, with reference to merits, you are telling us
No.
that you can argue. Yes.
I'm so obliged.
I apply for the respondent.
Challenging the order stated 26/2023, my lord, asked in WP number 6542 of 2023, present appeal is filed.
Not an order holding that petitioner is entitled, there is no adjudication
Yes, my lord.
on that.
There is no adjudication
And
and
what is And the learned single judge has not said that the petitioner is entitled to police protection. Anybody, supposing you are a citizen, right? You are a citizen, you make an application to the police authorities assigning XYZ reasons seeking police protection. The police authority should decide it, take an action whether you are this thing, whether you should be granted police protection or not. That's what it has been done. So there is nothing to object. According to us, there is no order.
My grievance is that, Milad, in pursuance of the interim orders, he has constructed fencing around my land. That was not
Then file a suit for mandatory injunction.
Milad, with the help of the writ court, Milad, he even this honorable court also.
No, you point out from the order where the court has said that he will be permitted to encroach with the police assistance on your land.
But in fact, the interim order is otherwise, Milad.
You are trying to say this. Please show us from page 11.
Milad,
The order.
Yes, Milad.
We are in this intra-court appeal. We are examining the by the learned single judge, not the fact whether or not he has encroached your land.
Milad, he did not
read the order.
Milad,
we have not read it.
Milad, I do agree.
We have not read it. For our sake, read para 2 and 3 and what has been done, then argue. We have not read it.
The grievance of the petitioner that though he made a representation dated 16/2/2003 for providing police protection, respondent number 3 is acted upon this representation till date. It is also erroneous, Milad. In pursuance of the
expert comments come later, para 3.
Without going into the merits of the case, respondent number 3 is directed to consider the representation dated 16/2/2003 submitted by the petitioner in accordance with the law as expeditiously as possible. My contention is that, Milan, in pursuance
para 4, first read para 4, then contention.
With the above direction, the petition is disposed of no cost. But it may look like innocuous, Milad. The problem of the appellant is that, Milad, in pursuance of the interim order granted by this honorable court, he made.
There is no interim order.
Interim order is at page number 119 to 120 is the operative portion.
What happened to your representation?
May I clarify?
So have you been provided police protection?
Yes, police protection was provided. The land was fenced also. Subsequently,
that is exactly my grievance.
Came up before this honorable court.
This you simple sentence you should have said that the direction contained in the order has been acted upon. When?
No, it was acted upon.
Representation decided on when?
Pursuant to the interim orders, the interim orders are page 1.
But again,
it was immediately after the interim orders, it was March ending, the date exactly.
So simple, these are so confusing. No, the representation is decided or not? Not decided. Your representation has not been decided by the police authority.
Interim orders.
No, for police protection, was it decided?
Yes.
Presentation 16/2. When was it considered?
It was considered end of March, probably around 29th March, that in view of the interim directions, the police protection was given. I have fenced the land. Probably it was my mistake also, it was fenced. What all I say, may I say one only, sir.
No, we have to hear him.
Yeah, your lordship may kindly say that he has obtained judgment and decree against some other person, some other land. He filed a representation for some other land. He obtained measurements of lands for some other land and fenced around my land. And he did not traverse any of my allegations or averments made in support of complete petition, stating that he fenced around my land. Without considering all those things, my lord, the fencing is allowed by the learned single judge. But I have filed and I.
Then, Mr. Again, you are making incorrect, false statement. We made you read para 2, 3, and 4. Despite that, you are reading the order. You are saying that the single judge has directed fencing of land. There is no direction.
I stand.
We will impose costs on you, and we will say that misleading the court is a misconduct.
Not misleading.
Where is the direction by learned single judge?
There is no direction.
Then how are you saying single judge has permitted him to?
I have filed. I stand correct.
You make submissions 1, 2, and 3. That's all within 2 minutes. It's not a case worth this thing. What ground you are challenging the order passed by learned single judge? directing to decide his representation? What ground?
Learned single judge, my lord. Your lordships may kindly see page number 24 to 25.
Do you tell us submission?
My lord, the writ petitioner filed OS number 35 of 2022 and the same was decreed in which I am not party. My lord, the suit scheduled property is acres 0.31 guntas. Acres 0.31 guntas.
35 guntas. Only 35 guntas.
35 guntas of
31 guntas. LS2 have situated in survey number 85, 102 and 107.
85,
102 and 107. I have nothing to do with that property.
The court is also not saying that court has not decided that he is the owner of survey number 85 10210.
Yes, Your Lordship. The court is not saying.
Yes.
But
This thing, what you are saying, you have nothing to do with 31 guntas of land.
Yes, Your Lordship. The writ petitioner also filed a WP number, my lord, page number 96 to 100.
What WP number? Seeking same police protection which was dismissed.
Not police protection, my lord. His grievance is
how these facts are relevant.
Sure. How these facts are relevant. That was a applying application filed to demarcate the land. Survey and demarcate.
Under the guise of demarcation, interim orders shall not go beyond the final orders.
Demarcation, have you filed your objection saying?
No, I was not invited. In fact, I was prevented from entering into my own land.
Remedy as will be available in law.
See, if somebody, by virtue of the orders, interim orders or the orders passed in of the other writ petition, is trying to encroach into your land.
Encroachment with the help of the police.
Listen, allow me to complete. If you are trying to encroach and say this is my land, the first thing you should do is this is survey number so and so, so and so. Because the order passed in WP 32782 was to demarcate the land. In survey number 82 was some other survey number, which is in the page number 26.
Yes.
Survey numbers mentioned in 85, 102 and 107. So when survey was sought to be conducted, have you at least put in protest saying these lands are not the same survey?
Yes, that's what. Yes,
No, so you have filed this appeal to seeking a direction to remove encroachment from your land, right?
Yes, sir. Yes. Right. But the writ petition,
so this is the, according to you, this is the scope of the appeal.
But may I just submit one thing?
All right, we have understood. Fine.
Based
this intra-court, that's it.
One.
You are seeking a direction for removal of encroachment made by the petitioner on your land. This is
not that, my lord. Under the guise of interim orders, the writ petitioner constructed and erected fencing around my land.
What were you doing?
I have objected and that's what my...
No, you objected and you did not bring it to the notice of the learned single judge when he was passing an order.
I have brought to the notice, my lord, page number 128, your lordships may kindly see. I submit that, para 10 minutes. Para 9 onwards. I submit that in spite of the same, writ petitioner tried to level the scheduled land belongs to me by throwing some soil on 24/3/2003, for which my husband...
we give you 3 minutes more. This can't go on like this thing. Absurd manner. It can't go on like this. You're not prepared to understand. You don't understand we have made you read the order. Despite that, you are saying that I am seeking a direction for removal of encroachment. Height of it. Height of it. We have read your prayer also, recorded your submission. Conclude within 1 minute.
My lord, your lordships may permit me to read my include
nothing. No permit. This is an order you have read. What is wrong with this order?
The learned judge, had he adverted to the facts and circumstances narrated by me, my lord, he would not have passed this order.
Fine, correct. Nobody is deciding the question of title in this.
I am not. My lord, these governments.
Court appeal. Yes.
May I just one thing, I may permit to remove the fencing on my own expenses, my lord.
So you want court to give protection to you. What
My lord,
will
the
happen?
police are
Us to take the law into our hands.
my lord,
You don't do anything. When somebody enters your land, tries to erect a fence. No. You only file a IA to impede yourself. Don't take any steps by approaching the competent court.
my lord, by that, my lord, I may permit, my lord, if I am wrong,
Nothing.
my lord, I may permit.
We will hear you for next half an hour, subject to payment of cost of 1 lakh rupees. Argue.
My lord, it is.
What is this, Mister? You don't understand? You again read the order. This is an intra-court appeal.
I have
not a suit for mandatory injunction, granting a decree to remove encroachment for your land. What is wrong with this order?
My lord, the representation was already acted upon. There is nothing to decide. And in fact,
what is the harm then?
Cause of action arose to me, my lord, when he made fencing around my land.
Make a complaint and file like a petition that I have made a complaint to police. They are not taking any action.
That's what my grievance is, my lord.
This is not the scope of the appeal. You argue whatever you want. We will not ask you anything, argue. Yes. Yes, anything. You read whatever you wanted to read.
I am permitted to read, my lord. There are 9, my lord.
Only Mr.
One,
3
page
minutes.
number 128.
3 minutes. You argue, conclude. Yes. Page number
128.
Read.
I submit that in spite of the same, writ petitioner tried to level the scheduled land belongs to me by throwing some soil on 24/3/2023, for which my husband, namely Nageswara, had approached the police station. That is fourth respondent in WP number so and so. And my husband forced to execute an undertaking that till 31/3/2003 we shall not enter into our own land. However, all of a sudden, writ petitioner, with the help of the petitioner on 29/3/2023, has erected the fencing by covering the scheduled land belongs to me. That is plot number 43 in an extent of 281.
Read, Mr.
281 is situated layout made in survey number 93, 94, 95, 96, 100 and 101 Moti Nagar, Khammam town district. Immediately we have approached the fourth respondent in the writ petition and he has orally stated he has acted as per the directions of the Honorable Court passed in WP number 6542 of 2023. And further stated that if we have any grievance, it can be resolved through the court alone and he cannot do anything. That's what my grievance meant. I don't trouble your lordships for that. With the aid of the orders passed by this Honorable Court, the writ petitioner erected fencing around my land. That is the cause of action for filing incomplete petition. Incomplete petition was ordered unopposed. IA number 4 of 2023 was filed. And in these affirmaments are made. No,
you were a respondent in that petition and see. We will not say anything. Go ahead. Go ahead. Yes. So incomplete petition not considered.
Incomplete petition was ordered and I was included as sixth respondent. I have adverted all these facts. No facts are traversed by the writ petitioner denying these facts. He did not say that it is not my own land. He did not say that fencing was not erected around my land. That is how, the grievance of the appellant. I am very sorry if I waste any time.
No. Please, anything else?
Nothing.
That's all?
That's it.
Thank you. This intra-court appeal has been filed. Yes. What should we do? Ask for items. Not to be. Ah. So you appear for respondents, Mr.
I am appearing, my lord. Litigation department, my lord. Respondent 2 and 4.
And all respondents are represented?
I am for the first respondent.
Whatever, all represented?
Yes, yes.
So we are granting this leave. What do you say?
Is it a panchayat land or a private pata land?
No, my lord, it's a Sangpet, my lord. Kindly see page number 37, my lord, once. 37 months. They filed village map, my lord. Survey number 269 shown as a water body. Page number 37. Top, my lord. 269. Eramala Cheru. It's a clearly water body, my lord. Generally, what happens is whenever there is no water in my villages, they might have run for this area for market yard. That does not mean that, my lord, they are having some right over this land. And admittedly, my lord, as on today also, they are not having any approval from any competent authority saying that it is allotted to them as a market yard. Admittedly, water body, my lord, this is.
All right. Yes. No, but
Please address us in the mic.
Mic,
We are
mic.
unable to hear.
No, Mr. As per the map, it is a tank. Tank cannot be allotted to any of the farmers or any person living in urban areas also. No tank or water body can be allotted. This shows that it is your map itself, revenue map shows that it's an area of tank.
It's a map filed by the writ petitioner, but the revenue record shows it is a portable land. There is no tank in existence in the survey number covered by the survey number 269.
So it is.
Therefore, villages constructed the market shed and using from the last 10 years. But the writ petition filed as if that the tank in existence.
What? Have you filed a village map to show that the land is shown as a Bandacharai or some other land and not a tank? Please tell us. I am asking one.
I am a third party. I am not for the petition. And the villagers, I filed the.
No. So just a minute. I mean, this read para 8 of the petition. What has the learned single judge directed? That all encroachments from, just a minute, all encroachments from this tank should be removed. So you are obviously an encroacher. That's why you have filed this writ appeal.
Yes. We are not the village farmers. And we are not encroachers.
The farmers can be encroachers also. Anybody can.
The Poromok land that belongs to government, village farmers, themselves constructed the shed and they use it from the last 30 years. The writ petition filed making the repent as if the tank in existence covered by survey number 369.
No,
but all the record shows is over the Poromok land. There are no village tank.
Fine. I mean, I have understood. No village tank.
It is the record, the record of Poromok land.
Ah, yes.
The villagers,
Let him complete.
The village
Just there's no village tank, number one. Second,
it is used inside land, used by the villagers, farmers, as a market, marketplace.
Land being used by the villagers.
Villagers and every village at the market keep storing the paddy and selling and purchasing of the paddy.
Being used as?
as a store place for the.
As an agricultural land.
And no, I use it as a selling and purchasing of the paddy.
Selling agriculture produce.
Being used as area for market area.
Market for selling and purchasing of the paddy. By the villagers and neighboring village farmers.
Yes, yes.
So but suppressing this fact, with the repeal alone, made the as if the tag in existence surrender code 269 and approved the wrong code single jab out and by misleading. The almost dead, but saw the option as if that their tag in existence, directed to
so executive engineer also misrepresented and this thing, no played fraud with the court.
Because they all the
let alone petitioner, but executive engineer. Irrigation and command area also played fraud with the court.
Is the only Ritpish alone only will complain. None of the village farmer complain that there is the question of their existence. No, there is the existence of the tank and using by all village farmers. Is one Ritpish alone made such a complaint.
Fine. That's it.
So therefore, I'm sorry, because when once the government brought it was almost single judge, that the village farmers had made the dharna and as well as that just bring to lordship notice. But in the court of it filed by the government, but extracted by the judgment itself only, my lord. That page 20, my lord, your permission.
All right. Yes, anything else? We have understood it's not a village tank, land being used by the villagers as a market area for selling agricultural produce.
Yes.
And who played fraud? Which one played fraud?
The petitioner himself played a fraud that to misrepresent that the tank in existence.
Petitioner guilty of misrepresentation.
And false represented that there is a tank in existence.
Yes.
There is no such a tank in existence.
Fourth submission.
Yes.
Next.
My next submission is that so with the when once it is the villagers using as the market shed, the writ petitioner or the God would have been impeded the villagers farmers as the
petitioner should have impeded villagers.
Yes. Would have been an opportunity before this for the writ petition.
Fine.
So without including us, without hearing us, beyond or by, without knowing the parties, but on the only reference made by the writ petition, they never did that one. The direction is only consider representation. The order of the honorable judge is beyond that. My humble service to get that through honorable court is but only just permit me to read number 2, but the page number 22, page number 8, page number 22, page number 8.
Read it. Read if you want.
Bringing the satisfaction on the record. The repetition disposal directed the respondent further to take all necessary steps for complete the protection of the minor irrigation tank. Elmal Kudi, Tungaturthi village, the case of the Mandal, Nalgonda district, and so external so on so from encroachment. The honorable judge reached that we are the encroachment the village tank. But the direction sought from the honorable court is where to read page number 16, my lord. What is the direction sought by the writ petitioner?
Page
16, my lord.
16. 16.
Yes, 16, my lord. Here number 2. Next sort the petition is to issue writ order or direction, more particularly one in the nature of the writ of manner declared inaction of the respondent disposing of the representation date 22/1/21 for protecting the minor irrigation tank. Only what sort is only direction consider the representation only. But the honorable signature reached the conclusion that the village encroached land that as if there is an existence of the village tank. But that was one of my grave grievances before lordship. So there is only consider representation. That is the scope of the repetition. But beyond the repetition, the honorable judge reached the conclusion that there is a tank and we are encroaching and directed the official to protect it. Based on the order, now the official made attempt to remove the sheds laid by the farmers. So therefore, we filed the tribunal by seeking the leave of this honorable court. That was my grievance.
Thank you.
Yes,
my lord. In this writ petition, my lord, we file counter. Counter starts from my lord, page number 22. Sorry, my lord, 27 months. My lord, kindly come to that para number 2, which is at page number 28, my lord. Para number 2, my lord, we have given the details of this tank. In fact, my lord, this tank is an identified tank. ID number also be given, my lord. Total extent of this tank is 7 acres 14 guntas. HIGHCOURT is 30 acres. And my lord, coming to paragraph number 4, my lord, under Mission Kakatiya program, my lord, we have government given a GO dated 3/3/2017, allotting my lord 11 lakh rupees for restoration of this tank. In pursuance to this said GO, my lord, in fact, this work was also entrusted to one contractor. The agreement date is given, my lord, as 23/3/2017. My lord, when the contractor went to the site, my lord, there was some obstruction by some of the petitioners, my lord. Then concerned assistant executive engineer filed a police complaint. Continuously gave 3 police complaints, my lord. Still they are pending police complaints. And my lord, coming to my lord, EE also wrote a letter to district collector, my lord, which is at page number 36. Intimating all these facts, my lord, to the district collector. My lord, in view of this page 36 and criminal complaints, also village map, my lord, it is clear that, my lord, subject land is a water body.
All right. Anything else? That's it. Yes. Yes, madam. This intra-court appeal is filed against
May I please?
Hmm.
The appeal has been preferred, Your Lordship, against the order of the land single judge in exhibition number 3754 of 2023.
Oh, you have the remedy, right?
Sir, Your Lordship.
Grievance is that, what is your grievance?
Lordship, the prisoner is the victim in the hands of the respondent number 5, Your Lordship.
No, what is your grievance?
Lordship, the
FIR is not being registered against someone.
has been registered, Your Lordship, but the police concern did not conducted the fair and proper investigation basing on the complaint, Your Lordship.
So then file a this thing complaint under section 200, take recourse to CRPC. You have the remedies available. How do we in a writ petition decide 156(3), 200? Don't invite our order. See, Mr. In a writ petition, we cannot adjudicate whether or not you may be correct. But we cannot return a finding that police authorities have not conducted proper investigation. You are aggrieved. 156(3), you can seek. Right?
156(3) is there, Your Lordship.
200 CRPC.
During the, after registration of crime, Your Lordship, the prisoner lodged the complaint against the concerned SHO for threatening, Your Lordship. The concerned SHO and accused respondent number 4 and 5, both are colluded to each other and threatened the prisoner to compromise the man.
No. You want registration of FIR against SHO?
Not that. I am intending to change the investigation officer. Change the investigation officer to.
This is not the prayer in the petition. Just a minute. Criminal jurisdiction. Ram Kishan Fauji.
Not that you do not know, Mr. Bhaskar. You are only wasting the time of the court and trying to test whether our memory, making it very clear.
You know, right?
Kindly appreciate the nature of the offense. 370.
No. Mister, we would have intervened provided you had no remedy. But we are more than satisfied that you have remedies under the. You want to do everything here. That's the problem. What my lord said 156. We can see you better withdraw. Better withdraw it with the liberty to take recourse to the remedies. Mr. Bhaskar Reddy. Rao. Whatever. After Mr. Rapulu Bhaskar, learned counsel for the appellant. After arguing the matter to some extent, learned counsel for the appellant seeks leave of this court to withdraw the appeal with the liberty to take recourse to the remedies remedies which may be available to the appellant for redressal available to the appellant in law with regard to redressal of his grievance. Accordingly, the appeal is disposed of in terms of liberty.
Requesting for tomorrow, Lordship.
No, not tomorrow. Yes.
Because he has some personal inconvenience, Lordships.
Yesterday we
Has throat infection.
similar matter was there yesterday. What happened? What date did we give Mr. Govind Reddy?
My lord said admitted it for hearing. Petition is admitted for hearing. Which is the number, if you can tell us?
Not admitted, Lordship.
Yesterday's matter.
Not admitted, Lordship. In one petition, orders are passed, Lordship. That's the reason we have it tomorrow, Lordship.
Order?
8 and 9. Lord. 8
So
and
which number order was passed yesterday?
Okay, we'll have it tomorrow, Lordship.
No, nothing.
They will not.
It was pass out. Pass out the matter bill.
We know, Mister. Don't. This requires a human effort, printing of causeless something, and don't time and set it not tomorrow, Sunday, Saturday. I will come to the court Sunday. Nothing.
Yesterday matter 21. What happened?
21 item. We will tell you what happened. It's our duty, no. We have taken note to do justice, so we should do justice. For you, it is very easy to say that this court passed an order. This case, same very court passed another order. We have to own the responsibility. Don't do anything. You just stand.
No, that is about the High Court employees.
After notice matter.
Yesterday, the similar matters had come up. You don't have the number, Mr. Bharat?
No, he doesn't.
Immediately
Kindly.
Give the number of yesterday's matter, like the same matter had come to matter.
Two matters were listed. Yesterday's list, we will see from his, you and Mr. Prabhakar was only appearing, right?
First one was item 7 or 8, my lord, subject.
Item 7 T Teja Kundaviti. Senior counsel appeared. No, that is not that matter, that is bank matter. Your name was printed, Mr. Govind Reddy, yesterday? One. No. This is.
Otherwise, my lords may kindly pass it over. I'll be able to assess this honorably.
Fifty-one, madam.
Same matrix, no? Mr. Gold, yes. Social welfare. This is that social welfare or electricity?
No, my lord, it's a civil supply.
Civil supplies, civil supplies part.
Not social welfare.
Yes, GP for civil service.
Petition is admitted, Mr. Don't say.
One more matter was.
Mr. Prabhakar appeared, we admitted it. Don't Mr. Incorrect submissions. In any case, it is listed for admission, we are admitting it. Petition is admitted for hearing. Noted. He appeared, it has been admitted, he argued.
The same day, two matters was listed, Lord.
No.
Which matter was?
Civil supplies matter, item 7, for yesterday.
It is open for you to file an application for review or challenge this order of admitting the petition before Supreme Court. Fine. We are not sitting here to convince you about everything. 8 and 9 admitted, notice.
Please, the matter pertains to the admission into undergraduation of MBBS course. Petitioner belongs to BCA category.
It is not notified. We often we not challenging, asking.
You are not challenging the rule which does not provide for BCA, correct?
How can direction be issued to in contravention of the rule? Read the prayer clause. You have drafted. We have not drafted it, Mr. Correct, Mr.
Yes, Lord. Yes.
The caste which he the caste which he belongs to has not been notified, and he is not challenging that this thing.
Yes, sir.
So that's what our query is, that how can a relief be granted to him in contravention of an existing provision?
Yes, sir.
He is not challenging that provision which does not.
And the caste to which he belongs is not recognized in state of Telangana.
That's what. You are not challenging that this thing.
But I may permitted to amend the prayer.
Learned counsel for the petitioner praise fund is granted. How much time?
10 days,
10 days time to enable him to amend the prayer. Sought in the to amend the prayer clause in the petition. List after 10 days. Yes.
This matter challenging the GO 75, which removes the sports quota from the MBBS and BDS courses.
No point of it. That.
If GO is at page 159, by this GO minutes, the sports quota from the admission into item number 42.
No, but there is also, so we had ordered notice in this matter.
This is the fresh.
Out on the question of admission, petition is admitted for hearing. Notice.
There is a judgment of His Lordship Justice Ram Subramanian. If I remember correctly.
Interim order.
I have filed that.
Interim order, not judgment.
I'm seeking one relief. It's IA 4.
No, even for sports quota,
Sports
His Lordship,
quota,
if I
sports
remember
quota.
correctly, said this is nothing but, they get certificates of handball, football, everything.
Let's I have filed that.
Interim order. Page 63.
Now seeking suspension.
It's a time.
Thereafter, a final order was passed at page 81. Thereafter, a final order is passed at page 81.
81.
Yes. If I draw your lordship's attention to the.
So what you are saying that this GO is contrary to the order passed by division bench of this court in WP 22700/18.
Correct. Well, it's at page 19.
No, submission is like that.
Yes, there was a direction.
No submission.
There was a direction to form a committee and see that whether this sports quota is really effective. And a suggestion was also made, Millets, that if they can, then remove the quota itself. My respectful submission is, Millet, they have not undertaken that activity. Subsequently, one more GO was issued at page 101, Millets, GO2 dated 22/9/2020. What they have done in the present, in that GO was, Millet.
So we will have to ask them what is the justification of removing the reservation for this sports category.
For that, I am seeking your lordship's indulgence to
what interim order?
Interim order in IA 4 of 23 to
By
produce the
giving
copy of the
admission.
report. I am seeking the copy of the report.
But they will file with the counter. Petition is learned counsel for the petitioner.
You are, that's NCC, along with this.
NCC, let us see what NCC we have passed some order admitting. You tell us.
Right.
Next matter. Yes.
My lord, I beg to represent my. My lord, though my lord, I am walking on a thin line, my lord. My lord, the writ assails. The orders.
That's what we appreciate really. So we are bound by our view and like Article 141, little choice.
That's my only contention was, my lord, the honorable tribunal exceeded its jurisdiction under 17.
This ground can be raised in an appeal. Appeal lies under 18.
18, yes, that's true.
In this writ petition, mark his presence in this writ petition, the petitioner has asserted the validity of the order dated 5/7/2020-23 passed by the Debt Recovery Tribunal in an appeal under section 17 of the Act. Then we have
That on the grounds rated, liberty may be granted to rest all the grounds in the writ
Needless
petition.
to, needless to state that all grounds as may be, may be available to, the appellant shall be, petitioner shall be at liberty to raise all grounds which are available to him in law in such an appeal. Yes.
In this map, Lord, the main point, Lord, where the contention before this are forum non-juris. Lord, a tribunal, Lord, which is having the Hyderabad.
Surface, which this sale proclamation of sale issued under which act?
RDB. Recovery.
Recovery 93 Act by the executing court, recovery officer.
Yes.
Appeal.
Lord, on the ground that.
No. We are asking you appeal lies or not. We will see that no appeal lies. Order passed by recovery officer straightway appeal can be challenged in a writ petition under Article 226. Is that the position?
Because on the
we would like to examine. I haven't seen 93 Act for a long time now. We have been dealing with such
that the
RDBB, Recovery of Debts Due to Banks and Other Financial Institutions Act 1993. If my memory serves me correctly, probably there is section 28 or something which provides for an appeal.
20.
Can't be.
20.
20 provides for an appeal.
Appeal.
Before the debt recovery tribunal.
Lord, again is the order of the DR team, Lord, whose jurisdiction, Lord, is.
Proclamation of sale issued by whom?
Recovery certificate, Lord, issued by the Hyderabad recovery.
No, this
recovery office.
You are challenging 19,623.
No, I am challenging, Lord, both.
In this writ petition, you are challenging 19,623.
Yes.
Correct?
Yes. Including recovery certificate also. May I just pass on the list of dates, Lord? I have just. May I
give us 2 minutes. 2 minutes. We are only asking you what have you impugned this petition?
In this writ petition, recovery certificate. 9/2/2020.
Issued by whom?
9/2.
No. Recovery certificate issued by?
Lord. DRT, Lord.
DRT. This is issued pursuant to what? Or straightway issued without adjudication recovery certificate?
Order in OA number 611 of 2018, Lord.
Order?
In OA number 611 of 2018, filed by the Lord first respondent hearing.
So this was a judgment in OA?
Yes.
What is the date of judgment?
Judgment is Lord dated 30th August 2019.
So this order, against this order, no appeal lies according to you. This 30th August.
Again, is this order not appeal lies? But again, Lord, meanwhile.
You didn't file an appeal.
No, I did not file an appeal. Meanwhile, Lord.
Under which provision 20 appeal lies?
Yes, 20 appeal lies.
Under section 20 of 93 Act appeal lies, but you did not file any appeal.
Lord, my submission before.
No, we are trying to understand facts, Mr.
That's. I just understand this.
Please. No, the simple query is still you have not told us who has issued the recovery certificate is issued by DRT in an execution
of the order.
In an execution proceeding.
Yes.
And I had the impression that probably the recovery officer initiates execution. No. Nowadays, the recovery officer is not there.
The basis of certificate issued by the Lord Tribunal under section 19.
1 minute, please give us. Six 9 crores cash credit term loan of 15. Don't want to pay and argue everything. Characters. See, 13. Yes. 28 plus. 28. Yes. All this. We want to say this. Even though legal we return to this feature. It's 26 whatever. Company becomes sick, they become rich. So, principle is, fact is, that this person has failed. Connected with this transaction cannot be by what we can imagine. And opposed it. It's obviously they have to be protection to yes, these people to recover the public, they become rich, company becomes sick.
The protection is to the company, not to the guarantors under IBC.
Yes.
That is
You are only guaranteed.
whatever it is. That's why I'm saying the protection under IBC is only to the company. I was sharing with his lordship the same thing. In all this IBC and all these things, the promoters become rich, company becomes sick.
Yes. If you have any alternative remedy, we are putting a query to you against this order. Please be answered like an officer of the court, not a counsel. We will not record your submission. A concession that you have a remedy. Do you have a remedy?
But,
No remedy.
it's not such
That's what. So the order is applicable under section 20, correct? Yes. Oh, yes. We have read it. Appeal lies except against an order made with consent of the parties.
But now the present plot, subject matter plot, where I am appealed, is the recovery certificate which is not issued in pursuance of that order.
That is a ministerial act of issuing recovery certificate. It is preceded by an order against which an appeal lies. In that appeal, you can assail the validity of recovery certificate. So which against this is recovery certificate is preceded by which order?
30th August 2000. 30 August, order is dated 30th August 2019.
Yes, yes. Which is filed not in order is not in without jurisdiction. Therefore, consequential will also.
All right. Mister, whatever you may argue, you know, we will, of course, we are under an obligation to hear you. Whatever you may argue, whatever you may do, the fact that you are a guarantor to this thing, public money to the extent of 26 crores, 88 lakhs cannot be wiped out, whatever you argue. Right? That is the fourth thing. And you owe a moral responsibility to pay the amount. And with your eyes wide open, you gave a guarantee and this amount is due. Whatever, without jurisdiction, within jurisdiction, all this happens. Yes, please. Go ahead. All please. No, what if we tell you that jurisdiction of this court under Article 226 is not only extraordinary but discretionary? Your conduct of being a guarantor and a defaulter is entitles you to any discretionary relief. In the facts of the case, we are not inclined to invoke this jurisdiction to grant you any relief. Tell us. Nobody can compel us. There may be legal position, 10 Supreme Court judgments in your favor, but we don't want to entertain. Discretionary. You cannot compel us to exercise equitable, extraordinary, discretionary jurisdiction.
I'm not lost in my submission that you last. It's not
No, just off the please go ahead. Please. No, we said that we owe you, we will hear you. Please go ahead. Yes. Just in interaction, we please.
Second question, not in first.
Yeah.
It's not there.
No. What is? You please go ahead with your submissions. We have this. We have gone through. Thank you for this. Now, yes.
Lord, in the OA Lord 7 of the Lord, we have filed that such
6, 7.
And second page, God start.
This 611.
Page number 8, yeah, not I. May I just.
No, so first submission is that the order issuing recovery certificate is not applicable.
Yes.
All right. Recovering. Issuing. But it's an order, right? There is an order issuing recovery certificate. It's an order, right? All right. So you say that it's not applicable under section 20. Yes. Why? Any reason?
Lord, section 19, subsection 22.
Yes.
Subsection 52. May I just.
Yes.
Setting officer shall issue a certificate of recovery along final order. Not final order is not 7. Under subsection 20, for payment of fee, that is the interest under his signature, the recovery officer. For recovery of the amount that specified in certificate.
So please tell us when the final order was issued in this case.
Yes.
When? Final order.
30th August 2019.
And recovery certificate?
19/2/2021.
Okay.
9/2, sorry.
9/2. Yes.
But my second submission is during the issuance of the.
So have you filed an appeal against final order? No. So, for our this thing understanding, we want to understand it should be like this, subject of course to your what you make, that in the final order after adjudication, the debt recovery tribunal determines the amount, and probably the recovery certificate. What does it? It indicates the manner in which it is to be recovered. What does recovery certificate say then? Why final order and recovery certificate? There must be a pro forma of recovery certificate to this act.
Recovery certificate provides.
Do we have a pro forma? No. Form 10. Form 10.
Page number 1.
Page
21.
21.
Form 10, I think, is the recovery certificate format, which is attached to the order.
Not
Yes. Not page 20.
no. Procedure rules.
Page 20. Recovery of certificate. Now 23 is not the
Not here. And this is debt recovery. Primary procedure rules, it's not there. Only up to form 4. Probably no form. Yes. A no form, right? Where is that? What are you challenging in this? 20. 20. This is some.
Only not the in terms of final order printed 30th last.
To recover to some mountain, so it's 23. So until you miss this order, what do you get? You don't get consequence. In terms of final order, recovery certificate issue. Yes, we got it. Yes, Mr. Counsel. Yes, yes, we have seen that. So first submission is that this no appeal lies against this order under section 20. Now second.
Second, even otherwise also not that OA and the recovery not is not I will be without any jurisdiction, not get to get jurisdiction also not at least. Specifically not section.
No, but in OA, you are party.
I took
You have suffered an order like 30th August 2019. You have not filed an appeal.
But I specifically took a ground with regards to jurisdiction. Not in my given statement, I filed for.
So what is the second submission?
Page number 83, not 9, not.
Please tell us, like, what is submission, your submission, second.
That not specified that.
It's not a listing in that sense, you don't be proving to say 90. When you he knows. So it is nullity. So case of, you will have to tell us that lack of territorial jurisdiction is a question, inherent lack of this thing jurisdiction, and the order is ab initio void, and you are probably relying on 54 Supreme Court to say that its invalidity can be set up anywhere, any stage of the proceeding, even in execution stage. Correct?
Yes, yes.
All
So,
fine.
Kiran seemed not.
That's the pleasure, right, of conversation, right? So, yes, correct.
Followed by several judgments.
That's correct. But you have to tell us that a case of that lack of territorial jurisdiction is one falling in that category. Only for that you may give us case law.
Page number 59 to
No. 59. Yes. This is AIR 54. This is correct. If an order is ab initio void, its invalidity can be set up at any stage of the proceeding, even at the stage of execution. No dispute with regard to this proposition. We are only asking you that this thing, having raised the issue of territorial jurisdiction, DRT having negated your plea, you having accepted the order by not filing an appeal, when the debt recovery tribunal issues a recovery certificate, against that you file a writ petition. In that writ petition, whether it is open for you to say that it is ab initio void. That's
though I raised conviction before.
what is then, Mr. What is the effect of not filing an appeal against the order passed by the debt recovery tribunal?
Not as far as the
In law, deemed to have accepted the order.
No,
It has attained finality.
For you.
But assuming that even if it is not attained finality, once the order itself is brought without jurisdiction validity, but I base not that.
No, you allow an order to attain finality. In execution proceedings, I'm just giving an example. You allow a civil court order to attain finality. When I initiate execution proceedings after, let us say, 10 years, can you say that order is wrong? That is what is happening here.
That exactly not the Supreme Court products.
Hi.
And exactly not the Supreme Court.
Yes.
Such treatment not follow. I cannot accept not both Supreme Court.
So therefore, so again, this question that since the action of issuing revenue recovery certificate itself is per se without jurisdiction, therefore alternative remedy is not a bar. Your case is covered by whirlpool exception. That anything else? That's it. Two submissions.
One more submission. Meanwhile, the National Guard is just.
Then you have to one more submission is that you have to answer our query that issue, as we are inclined to think that issue pertaining to lack of jurisdiction is a mixed question of law and fact, not in that sense purely a question of law or a legal issue. There is no statutory bar. What is, you are saying territorial jurisdiction. What is the objection raised by you with regard to territorial jurisdiction? What is the finding by DRT that you show?
So there's no fighting by the DRT with respect to.
What objection you took? What is the objection taken? 83.
Starts from
No, simply saying no jurisdiction that everybody says. You have to substantiate.
Page is 8.
Yeah, 83. Yes, please. This is your counter written statement by the petitioner. Yes. Which para?
Para 9, page 8.
Para. Same, no jurisdiction. What? Whether any this thing, 1 minute.
Specific
DRT. Then no three. This thing, where is the order passed by DRT?
Page 41.
41.
41.
Oh.
47.
Oh.
Page 44, there are three
One,
departments.
one.
Right?
One.
Page 44, paragraph.
Yes.
Four lines from bottom from paragraph.
Availed from Vijayawada branch.
Exactly. And the rules are defendant submission from Vijayawada branch, and applicant branch has no locus branch.
So
Right, we are it. Further thing, as of action, number goes, and the defendant knows about this, not accordingly.
So your submission is that though you raised an issue, it was not decided. Next question is absolutely good. So, Mr. Please tell us, in such a case, you can set up like we wanted assistance from you that in support of your submission, that in case you take a plea that a forum has no territorial jurisdiction to deal with the claim, that would render, and supposing if that particular forum takes pass an order on merits, it will have, the order will be void.
That's what.
Yes, that's what. Which judgment, which paragraph?
From 59 onwards, not the. Page 59.
Yes. Yes.
There are 6 blocks. Sorry, I was underlined like instance. That's
Yes.
it's fundamental. Passed by without interest in that. And it's invariably to be set up whenever and wherever it is sought to be enforced or played upon, even at stage of execution, and even a defect of jurisdiction, whether it is pecuniary or pecuniary, or whether it is respect of subject matter of action, strikes at the authority of the mass and such a defect cannot be given by concept of office. If you question now under consideration, it's not general matter. Then we go to the next two of foreign markets and the next judgment becomes page number 17. That is order of achieving the better project versus
Yes.
page number 80, para. From 24 onwards, but the language is not yet. Respect of the student. Now, that's no period, you cannot be said that there was no question of law involved, as we have found out that the issues clearly fell in the area covered by the legislation tab. And but therefore specifically bar. The question is whether this issue regarding jurisdiction to be allowed to be raised before us. The question of jurisdiction came up before this the their lordships has referred to that under judgment. Not wherein their lordships extended with regards to this, we are able to uphold the convention. The jurisdiction of a court may be classified into several categories. The important categories are territorial or local jurisdiction, pecuniary jurisdiction, and jurisdictional subject matter. So far as territorial and pecuniary jurisdictions are concerned, objection to such jurisdiction has been taken in the earliest part of opportunity and its case. Or before settlement of the law is well settled on the fact that in such objection is not made. Jurisdiction and subject matter, however, is
So, we can. That's.
Page 25 about that.
So, Mr. Yes, anything else? Para 32. 80. Well settled. Non-nest. Yes.
Judgment is 6, not variable 6. Not balance, balance, 7. And
Yes.
once the performance is specified manner, we need to put the performance have been enforced here. Section 80, is not yet. Jurisdiction not yet, high school not the.
No, see, broadly, we are what inclined to think at this point of time. That's all. Let's see, we will deal with the question of alternative remedy. If we hold that you have an alternative remedy available, probably it will be open for you to agitate this question that it's a nullity in an appeal. Right? And in case we answer, you will suffer a prejudice. So we cannot say at the same time that an appeal lies and answer nullity here. Right? It will be in your interest to keep that plea alive for adjudication by us at a later stage. Right? Supposing if we relegate you to remedy of appeal and answer that this plea of nullity is against you, supposing, then what's the point? It is in your interest. So first we deal with the issue whether an appeal lies or not. And then reserve, supposing if we hold that appeal does not lie, appeal lies, then you go there. If we say does not lie, then you argue nullity and all that. There's nobody can dispute the law laid down proposition in 1954 Supreme Court. We are agreeing that if an order or decree is nullity, its invalidity can be set up at any stage of the proceeding. Nullity. So you tell us that it's not order issuing whatever is a recovery certificate is not an order, any authority. No, any authority. Any authority in law to support this proposition. Like we may say anything. It's very convenient for you to say, no, it's not an order. Please. What we are trying, it's very convenient to say that no appeal lies, not an order. But this question must have been dealt somewhere, not dealt with, we will deal. That's why we are asking any case law in support of this court must have decided, if not any other high court in the country, if not whether Honorable Supreme Court or any other high court in the country, this court not decided, then we will adjudicate. What is order mean? Order is must be defined under this act. Dictionary. IS dictionary. IS dictionary. IS dictionary. Black's Law Dictionary.
Black's Law Dictionary or Venkataraman's volumes, 4 volumes. Alphabet O. Alphabet O, the Venkataraman's 4 volumes dictionary. That was for.
Not challenge the finding of cannot question this certificate to make it not an order.
Which is actually is comfort the procedural aspect that is like the decree that because challenge to the order challenging the decree.
Yes. All right. Thank you, Mr. Pleasure. Huh? No, not necessary. We were perhaps this thing not necessary, whether it's an order or not, because it's not an order. It only says certificate of recovery, not an order. So they're not necessary. Correct. That's it. Thank you. Pleasure hearing you. Thank you. Yes, madam. Right. 24th auction. Mark the presence heard on the question of admission, Mr. So and so, senior counsel, whatever. Recovery proceeding initiated pursuant to recovery certificate.
Recovery certificate issued in persons of order in OA.
What is he challenging then? What are you challenging? You are challenging this recovery certificate, right? What is the recovery certificate dated?
Page 20.
Date?
9/2/2023. 9/2/23.
9/2.
Recovery certificate is 9th February 2021.
No, this is he's challenging proclamation of sale.
That is in terms of the RC.
So what is this 19/6?
19/6/2023.
See, that's what we have been, Mr. Counsel, we again take this opportunity. That's what we have been telling everyone. Instead of writing such longish prayers, if it para 1, 2, 3, it will be so easy to comprehend. What you are saying, we are struggling in first 6 lines. What you are saying comes in the next page at this thing, last 4 lines. Correct? Huh? All right. In this writ petition, delete everything. In this writ petition, petitioner who is a guarantor to the loan to an extent of rupees No, Mr. We will ask your colleagues to be more careful in drafting the petition, right? You have argued everything on the assumption that it is challenged where it is not so. That emphasizes our point that prayer should be distinct and separate columns. This is what omnibus, one column running into 10 lines, another column half a page. In that process, the substance is lost. This is what has been done. You see, you have argued the point, but this is, we have no occasion to entertain it because, yes, madam, one more minute. This last paragraph, therefore, petition, full stop, since, one line, last line in that petition fails and dismissed, since the petitioner has failed to challenge, since the petitioner has not challenged, the petitioners have not challenged the validity of the final order dated 30th August 2019 passed by the Debt Recovery Tribunal, nor the recovery certificate dated 9/2/2021 in this writ petition. Therefore, it is not necessary. While hearing. Thank you. Yes. Oh, but the interesting point you raised, without factual foundation, without seeking the relief. Good. After a long time, we came across 1954 Supreme Court 340, which was our favorite case at the bar. 54, very beautifully written. Yes. Lucidly explains the legal position. Yes. All right. Next. Madam. Yes, ma'am. No, it's all over. You have argued to your heart's content. We have heard it. 1 hour has gone in the process. Not after that. At least, Mr. Before arguing, you should have at least read the prayer clause. That's why we are saying all the more need for being precise. Mandamus seeking inaction on the part. This what like I mean we have not troubled you all on this, but every petition mandamus challenging inaction. If we put this basic question, how inaction can be challenged by way of a writ of mandamus? How are you seeking? Probably you don't have an answer in law. This is what is happening. One of the instances. Yes. NCC candidate.
NCC.
What order we have passed? Petition is. Petition is admitted for hearing. Rule NICI call for records. Notice returnable 4 weeks. Heard on IA 1 of 23. Any admission made against seats under NCC A and B quota in MBBS and BDS shall be subject to outcome of the petition.
Yes. I take notice for R6.
Whatever. Yes. Whosoever take right. Yes. Give whosoever appears and then notice to unrepresented respondents. Yes.
Obliged.
Yes. Yes.
Lord, this is with regard to spousal transfer.
Spousal. Covered, right, madam? Yes, you sought an adjournment.
Yes, my lord, it is not covered, madam.
Not. This you are saying as an officer of the court, right? You appear for which this thing company?
I'll submit.
Yes.
What submit means not for 1 hour.
I'll take only 10 minutes.
If you want it to be heard, then this thing, give a synopsis and then assess this court effectively.
Yes.
We are not asking you, madam. You sought time yesterday, we have granted. And the presumption is that you have to be ready. And we are not asking any question to you. Why should you respond?
Yes.
If you want final hearing, then this, Mr. at the motion stage, I mean, you can't be cruel to the court by this thing, asking us to note everything down. And we don't have, see, for passing an order, we have to state facts. And if you want out of turn hearing, you have to do so. Otherwise, it is for admission. Good enough point, we will admit it. Why? So, yeah. So we will ask them, your representation is still pending. Interim order is that only to consider representation. We will ask them to consider. Who will consider?
The consideration is to be made by the
Which person?
first response. I'm sorry. By the second response. That's the managing director. That's the Telangana state.
You consider the representation as an interim measure. We are admitting the petition. Heard on the question of admission. Learned counsel for the petitioner submits that the
The present bill has.
What? There is another pill on same subject matter.
Yes, my lord.
Huh?
Yes, my lord.
You know it?
Yes, my lord.
Then,
After filing, we have come to know that the earlier bill.
no, so like any other, he can also file another petition, same subject matter. How this can happen?
I've been diligently pursuing this cause, my lord. In fact, the petitioner had filed an RTI.
No, how are you concerned? You are a this thing contractor interested in this thing allotment of contract.
No, my lord, he's a social activist, my lord. RTI activist. He has been
Social act.
My lord, may kindly look at page 38, my lord, where he has filed an RTI application way back in.
No, Mr. What is? Are you an expert, financial expert?
No, my lord.
How? We are asking this. It has some relevance, right? It's some. If the questions are being put to you, it has some relevance. Not that I mean, just like that we are saying. So, what is the basis of your averment in the petition that this concession agreement executed on 28th May for collection and toll and maintenance of outer ring road has been undervalued? Are you a financial expert? Have you obtained the opinion of some expert body, financial body, saying that it is undervalued, or do you feel that it's undervalued?
They're not.
Basis.
Yes, my lord. They're not stated that it is undervalued, my lord.
What ground you are challenging?
Government to reveal the IECV value so that it can be determined, my lord. The government is not revealing the IECV value, which
Why?
it ought to reveal, my lord.
No, you are a social activist. Why it is this thing?
Initial estimated concession
Value is necessary for you to survive. I mean, if we can say so. Why? You can't breathe without this? Huh? You are
Like this, my lord. It's just a public cause, my lord, to satisfy the conscience of the public that the asset is
no
not being
conscience
undervalued.
to satisfy your ego and conscience.
Not like
This is what it is. So unfortunately, everything in our country is so misused to such an extent. As a senior counsel, I have defended most of the respondents in a public interest litigation. I know the antecedents from my experience. You must have gone there, arm twist, give something, they refuse, file PIL. How are you concerned? If you have you made an application to know this under the RTI?
Yes, my lord.
So then we will, that application, he will make a statement shall be dealt with in accordance with provisions of RTI Act. In case that information can be supplied, it will be supplied. They will take an action in accordance with the RTI Act.
Another bill has been already admitted, my lord. All we ask is for us to tag along with that bill, my lord.
I want only this value, initial estimated concession value.
Yes, my lord.
If you have made an application under RTI Act, they will have to furnish, and if they want to, they do not want to furnish, whether in what exceptions they fall, they will have to communicate.
And that order is appeal lies under RTI.
19, my lord, section 90. But we already communicated the information.
It doesn't mean that you make an application under RTI Act. They don't supply the information. You file a public interest litigation. In that case, are you expecting that this court would act as an appellate authority under the RTI, where the failure is on the part of the authority to supply the information? In that case, appeal also lies. Penal consequences are prescribed under the Act, and special counsel is happy to this thing, happy with penal consequences. Good. This is no PIL, nothing. Your grievance, you have the forum, therefore we will not interfere. This all process is complicated, done by experts. It's not for activists, neither for us nor for an activist to say that it is undervalued, this is not done, that is not done, right?
We're not.
You cannot say that you cannot say that the whatever airport or this thing, seaport has been given undervalued, this thing I should be given. You are not getting it right. And do you think that there is no competition for this? He must have come through a bidding process, right? And his competitors are neither illiterate nor so poor that they cannot come in writ petition and challenge the concession agreement. It doesn't take a social activist.
My lord, may kindly see page 23, the reliefs I have sought for, my lord. I've only asked for the revealment of the IECV value, my lord. And
So
since it's not
that
within
they
the
will
domain
do.
financial expense.
That prayer is being granted. That he will do. He will pass an order under RTI Act. When was the application?
It was made on 10/5, it was dated 10/5/2023, my lord.
10/5.
It was posted on 19/5/2023.
Just 10/5/23 application to whom?
To the second respondent, my lord, HNB.
Who's
Well,
second?
it was a respondent on behalf of second respondent. RTA. I appear to respond number 2. We have already responded to that. If it's agreed, Malad, he has to file appeal under section 19.
So you have this thing responded when?
I don't have the date exactly.
I'm not aware of any.
No. Not aware, not good. A social activist has to be aware about what is happening around him, right? All the time you have to be on alert mode. You shouldn't say that I don't know. File an appeal. File an appeal. Karan, yes. Mark the presence. In this petition filed as pro bono publico, the petitioner inter alia seeks a writ of mandamus to state of Telangana as well as
And I file a petition to.
Yes.
As suggested by Lordship, the description of the sixth respondent has been amended. I filed a petition.
Which 23?
Yes, sir.
Hence office objection sustained.
May kindly allow the petition. I will amend.
Learned counsel for the petitioner praise fund is granted. How much time?
I already filed a petition, Milord.
Heard on IA.
The description of the sixth respondent.
Heard on IA so and so. Permission seeking this thing allowed, right? To amend. Let amendment be carried out.
Yes, Milord. I will
How
carry
much
out-
time? Within 1 week?
1 week.
1 week. Yes, Mr. Counter. Mr. Praveen Kumar. Praveen Kumar. So then you have to file counter, right? Learn it. So 1 and 2 praise fund is granted 3 weeks further time to enable him to file counter.
File over a detailed period.
There is an interim order now. He made a mention for
Yes. You adjournment, right?
Yes, sir. Morning I mentioned, but I informed them.
He wants an adjournment. You are happy? All right. We don't want to adjourn in your absence. Otherwise, you would have said in interim order. Why do you want adjournment? You have got a good case. You could have succeeded by arguing.
Sometime maybe we can try.
Learned counsel. So, how much time do you want?
2 weeks time.
Learned counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same. No, he said 1 week. Don't. Learned counsel for respondent submits that twice. When, Mr.?
Next Friday.
No, when? That adjournment has been sought on behalf of the appellant once. Once.
He is for the appellant. He is the respondent.
So respondent is seeking. Also, you can't. So that's confusion. Fine. Mark the presence. So why should you say that only one time? You should say that let them take 4 weeks, sir. I don't mind.
You have an interim order.
We thought that you are opposing the prayer. He didn't tell us in the morning that, sir, interim order operates against me. I am happy with it. Please grant me 4. We would have granted in the morning itself. Mark the presence, learned counsel. So you appear for Mr.
Respondents,
all respondents.
Unofficial respondents.
So, Mr. You need not take trouble. He is appearing even for state of Telangana. 2, 3 Inspector General, District Collector. He appears for everyone. He said all respondents.
No, Milord. Respondent number 1, Milord.
Let's say so, Mr.
Respondent.
Say so. I appear for respondent number 1. Simple. You are appearing saying all respondents. So do you appear for, then we will ask you, how do you appear for state of Telangana? Which provision?
No.
Have you filed wakalat? Are you a government advocate? What happens to him then? He loses a brief. Learned counsel so and so, Mr. So and so. Learned counsel for respondent prays for adjournment. To enable him to prepare the case and argue the same, interim order shall continue. Appeal is admitted for hearing, you say. Appeal is admitted for hearing, prays for adjournment. List interim order shall continue during the pendency of the appeal. And then no 2 weeks, it is admitted. Prays for adjournment. Yes. To item 25, madam. Mark their presence. 2, item 25. IA 2 of 23 reasons assigned pro forma is there, no? Duly supported, sufficient cause for condonation delay of 169 is made out. Delays condoned. IA 3 of 23 requirement of filing certified copy of the order is dispensed with. In the result, IA 2 and 3 of 23 are allowed. Appeal is admitted. Why is this to be repeated into some, no? No, but there's no problem. There is a state by the time the appeal petition itself will be decided. 27.
Morning they took adjournment.
Huh?
Urgent the matter for enabling them to file counter. They have not filed so far any counter.
Acha.
Writ appeal, what counter?
Writ appeal, no counter.
Well,
We have
they-
been asking, no.
Yes,
They may
let
ask
it-
for moon also. But
And
we have
delay-
to,
in delay
we have
petition-
to, please appreciate,
In delay
you are
petition-
additional advocate general, which provision,
In condone delay petition,
Condone delay.
there 320 days, there is a delay.
how much this thing? Delay, how much is the delay?
340 days.
Oh, reasonable by your standards, right? Huh? Your government, right? Huh? No,
There was a delay, it's a delay.
no government or what?
Yes, it's a government.
State
Fine.
government, that's fine.
I heard on IA1 of 2023, despite opportunity being granted to respondents, no counter to IA1 of 23 has been filed. Paragraph.
Next week, madam, Monday.
Let the appeal be listed for orders on admission in the next week. 27, 28. We have condoned the delay, Mr.
The 340 days, my lord. Let me give an opportunity to file the counter, whatever the my lord
No.
be. My side.
Last time opportunity was given, counter is not filed. And this court is very bad about condonation of delay. It condones the delay. You will file with a delay of 341 days, same will also be condoned. 1 day extra to you, right? In any other case, try.
Because I
For my bench, if you file a petition for condonation of delay with 341 days, he will not oppose. And we have granted you opportunity once.
One request, the counsel on record became the justice of this court, so therefore, my lord, there is no information to my lord. That's why I recently received the my lord instructions.
Once we granted adjournment, it is adjourned to today. 8 days time was given. No prejudicial order. You should focus on contesting the matter on merits. Nothing is done.
Instead of 1 week, instead of 1 week, 2 weeks, my lord.
Huh?
It's 2 weeks, my lord.
What 2 weeks?
So I'll take instructions from the client, my lord, if any material, my lord. 2 weeks.
He wants, he is the appellant.
Yes.
Mr. Counsel, he is the appellant, right? You are respondent. Maybe that next week his appeal is dismissed. Who knows?
This matter is covered by earlier division bench of this honorable court.
So
Already covered by this.
you whatever you tell him,
Covered by.
list after 10 days. Fine. Let him seek his section. 10 days.
Fact. Yes, so please.
27. Delay condoned and we have adjourned it after 10 days, right? You seek instruction. Mr. GP for revenue, yes. WA. We'll pass over. Pass over there. It's 140, so that's why we don't want to pass. Item 32. Yes, madam. 32.
May I proceed to 38.
Yes.
I appear for the last occasion, they were directed by the counter, they have not yet filed.
Lord, here, GO number 21 has been challenged, issued by the General Administration Department, Lord. The petitioner failed to make the General Administration Department as a party, Lord. GO issued by GAD, Lord. 21 GO issued by GAD, we made party education department, Lord.
It's all internal this thing, you can make arrangements. It is not that.
You say that
administration has to answer the.
No. You say that I don't want to file counter. We will decide.
We will file, Lord. We will file next week, Lord.
That's what senior counsel is saying, that last date you were, time you should say,
issue
and raise that objection in the counter.
Yes, Lord. 1 week, you lost. By Monday, we will file, you Lord.
Last date only. It's not a fun, right? Adjourning cases every day and listing. And the next day you say 1 week more.
By Monday, we will file, you Lord.
Let them senior counsel, let them file in 2 weeks. He doesn't know. Learn it.
is not printed as childish.
Because you lordship, geo issued by the, which pertains to all the departments, your lord, not only for.
Sir, raise that objection, his petition will be dismissed.
Yes, your lord, we'll file
Don't
your
say
lord.
orally anything, not complying. Either you say, I don't want to file.
No, we will file your lord.
Don't file.
By Monday, your lordship will file your lordship. Oh, lordship.
You can argue, right, that GAD has therefore no relief and petition is liable to be dismissed on account of non-joinder of necessary
We'll file
parties.
counter with the.
Say so. He should get an opportunity to meet what you are saying. Just when the last date of hearing, you sought time to file counter. We adjourn it. Today, you are saying that GAD is not file an application.
I received paragraphs with regard to it, your lordship. Lordship may grant. Monday, I will file your lordship.
Then you should fairly say so.
Yes.
Last date only you have been granted 25th July, 2 weeks.
Yes, Lord.
That's why don't make it a process of this court a mockery. Every 2 weeks, then I will file on Tuesday. I will file tomorrow.
Only with regard to this aspect, your lordship, you do. Lordship may grant.
We don't know. We are not sitting here to advise what aspect. Who is your client?
Lordship,
who is your client?
Lordship, school
Respondents.
School, all the respondents. All the respondents.
Who will advise them what to do?
All the respondents.
No. Who will advise them what to do? You have been engaged to advise.
I will advise you, lordship.
So then why are you asking us? I will only cover it and this and that. Do whatever you feel like.
Lordship may grant 1 week time. Monday, I will advise, lordship. By Monday, we will file.
See, Mr. Rao, what is happening? Mr. Rao, see, your president, learned counsel for Mr. Dayakar Reddy, learned government pleader. Again, you are the same, no, Mr.
Yes, lordship.
Learned counsel for the this thing respondents once again. All right. If counsel is present, then only we take it up. Yes.
But matters are coming to the counter. Last time time was granted to the military respondents. Counter.
Made a mention in the
39, somebody made a mention of what statutory right you have to seek a allocation to a particular district under which law?
That guidelines framed by the High Court. High Court has issued the guidelines under which millet allocation has been done. I'm challenging the guideline.
Counter has been filed, right?
So High Court has not filed counter millet. Some of the respondents.
Petition is admitted for hearing. Let counter, if any, on behalf of respondents who have not filed counter be filed within 4 weeks. Yes.
These also
Same order.
Apply.
Lords, it's coming.
Yes, madam.
Lords, praying for the National Medical Commission, my lords, coming up with the counter of the respondents, my lords. The petitioner is praying for a PG seat, my lords.
We don't know what's the you are petitioner, right?
My lords, I'm for the respondent.
This the anybody, I mean, the law says you can't be. Who appears for petitioners? Pass over then, maybe break. So we'll take it. You call this 41 after at 2:30. So, madam, get the case law that this Supreme Court has said admission previous year, next year can't be adjusted.
Yes, my lords.
Get the case law. It's all Supreme Court.
Yes, my lords, I'll get that.
2:30.
Yes.
We will.
My lord's kind permission. My lord, your lordship directed me to. My lord's kind permission, my lord. In the morning, my lord, your lordship directed me to get SR number, my lords. My lord, when I do lunch motion.
No. So we said that you first file the petition, they may make a mention.
Yes, my lord. I have filed the petition, my lord. Now I got SR number, my lord.
Give the SR number, matter will come tomorrow.
My lord.
What is
my lord? The urgency is, my lord.
At 1:45 and tomorrow 10:30, what will happen? You tell us.
My lord, the urgency is, my lord.
What will happen?
My lords, results may declare, my lords. My lords, the university may declare results, my lords.
So let them declare it. So
My lords,
supposing
the
if
petitioner
you would have appeared in the examination and university won't declare the result, what would you feel?
But I'm appearing for this matter.
So
Yeah.
he said that he was mentioning, Mr. You should guide him properly, your senior counsel.
Yes, yes.
He was mentioning without filing the writ
Yes,
petition.
yes, I was there.
That shouldn't be done, right?
Yes,
Nobody
yes.
can do this, that without filing the petition, we give a mention memo and then he doesn't file a petition at all. Supposing if he changes the mind, then what is this not done? First, you advise the young man that he should always file a petition. Then as put it by brother, what happens between 1:45 and tomorrow?
I was only asked to appear after the.
So see, you have filed the petition. If result is declared, anything is subject to, you are already protected.
Well, the position appears to be small submission.
No. So are you seeking that an order that the university should not declare the result?
No. We are only seeking the declaration of the result in the manner in which my lords have given the order day before yesterday. My lords, wherein these persons were treated as locals. But this person.
Declaration of result.
It's not declaration of result.
That is with regard to MBBS.
MBBS.
Local.
Yes.
No.
Admission.
Unlocal and local.
Result.
They have been given.
For the second phase counseling.
Yes, they have been given permission to appear.
Yes.
On a provisional basis. There is no declaration of result.
Yes, we are only seeking.
What is the you want permission to appear in second round of counseling? Whether the dates have been notified. Second round. Our counsel for university told it is not notified as yet. Tomorrow it will come up. Ask him. Your friend is standing. He only told us that dates of second round of counseling have not been notified. Ask him.
Yes.
He represents
I was
university.
given to understand it's going to happen today. I stand corrected. I'll ask him.
So tomorrow.
Mr. Mayur, maybe the counseling will be open for at least 2 days or 3 days. So tomorrow morning, if we find your client is eligible, we can
deeply apply.
Tomorrow then it comes, right? Well, you should know the case, right? Mr. Young person, you should know the case. What is it? You want permission to appear in counseling. You are saying result.
Already.
Permission.
We are coming back. You don't want us to come back at 2:30. Then we continue. You are not feeling hungry, Mister? Early lunch, brother says. What is it? You also want them?
It's on respectful submission. I filed a petition on the SURFACE Act. The petitioner is due to the.
No. What urgency? Where were you at 10:30?
Respondents, bank authorities. So.
No. Where were you at 10:30?
Sorry, my lord.
Very sorry. We are also sorry. It's 1:40.
Tomorrow, you mentioned tomorrow.
Nothing happens in SURFACE matter. You know the law. There are 2 Supreme Court decisions. Despite that, you are filing a petition and asking us. We pass an order today itself, right now.
You like the permission, Milad?
Which order you have challenged? All the file. Right now. Which order have you challenged in petition? Which? Under SURFACE Act. So appeal lies under section 17. Go before DRT. Get his file. What's your name? Learned counsel for the petitioner. Heard on the question of admission. In this writ petition, comma, where is that SURFACE thing? In this petition, comma, the petitioner has assessed the validity of the order dated. Which order? Order not given. Then what are you challenging? By which notice has been issued to the petitioner under section 13(4). 13 cos 2 of the SURFACE Act. This you have the liberty to file an objection, right, to that 13(2). Then 13(4) measure follows. Then an appeal lies. Satyavati Tandon and 2022 Supreme Court has deprecated. We are following this. All right. Get the file. Have you filed it, Mr. Or not filed? Filed. So it is petition is disposed of with the liberty to you to avail of the alternative remedy under section 17. There can't be a faster dispensation of justice than this. At mentioning stage itself, you get an order. So nice, right, Mr. President? What do you think? Huh? So lucky, no? See the dispenser, how quick it is. At the motion stage, all right, granted, disposed of. Nothing. Order is passed, it's over now. 136, Article 136. Special petition.
Larger permission.
So that two paragraphs, Satyavati Tandon and 2022. This thing, Honorable Supreme Court of India, para 5. In view of aforesaid denunciation of law, we are not inclined to entertain the petition. However, liberty is reserved to the petitioner to take recourse to the remedy under section 17 of Surface Act. Line below, with the aforesaid liberty, the petition is disposed of. As a sequel, all this thing. Get it, madam? Whatever list and disposed of. Okay. You also want an order. Yes. We wonder, no one of you is, none of you is feeling hungry.
Yes, we are feeling angry, my lord, but
permit us to come back. One, it was an extreme urgency. That's why out of way disposal, decision on merits for him. You right? You know what's the name? Huh? Write his name, heard on the question of admission, everything. Huh? Copy today you want, but will also be done. Madam, type it, certified copy today. None has appeared on behalf of the appellant even on 24, on no, not even on 24/7/2020-23. Today also, when the matter was called twice, none has appeared. It appears, lying below, it appears appellant is not interested in prosecuting the appeal. Same is dismissed for want of prosecution.
I can copy them straight and give you the.
Yes, madam. What? Got the case law?
My lords, I couldn't locate it, my lords. I'm requesting time to.
Yes. What? Yes, mister. What is your claim? Who had assured you of a seat in the next year? You were selected when? For MD radiology course, right?
Academic year.
You were selected.
I was selected.
Then what
And
happened?
then I was not allotted a seat in the same academic year. I was promised in the next.
Who had promised?
The college.
So, how this court is involved in the promise given to you by the college, and seek your this.
May I take your lordships to
No,
page
sir.
89?
We want to know what is the, please, this thing, this writ petition is about enforcement of a statutory right, right? So right to seek admission in next academic year must exist in law if you want its enforcement. If you are banking upon his promise, it's for him to fulfill. If they give you admission, we don't have a problem. But once you seek a direction from the court, you will have to tell us that the source of right.
Even the university has promised us a seat, my lord, in the running academic year.
So let them, yes, Mr. University, why did you promise? Forged? Which one? Which one? Just a minute. Oh, serious thing. Which page is forged? Forged? All right. So file an affidavit. Serious thing, Mr. Learned counsel, Mr. Prabhakar Rao, learned counsel for respondent number 2. Respondent number 2, university submits that the email dated 22nd December 2022 relied on by the petitioner, which is marked as exhibit P11 with this petition, has been, what is your exactly your submission has been? Is not the email sent on behalf of the university. Full stop. He praise warrant is granted. 2 weeks time to enable him and to file an affidavit in this regard. So if he says no, then end of the matter.
We have filed.
Our matter is also challenging the same MS 75, which was directed by this court to Mr. along with this matter, but unfortunately it was not listed by lords. WP 1818.
So
Same GO has been challenged. Last time it was clubbed together.
where is that order? There is no order.
In our petition, WP 1816.
Your case is not listed. Let the council address whose case is listed, right?
My lord, I appear. I am the petition. I do not know, my lord.
Hey, you should not permit him to take charge of your case.
I was not sure whether he is talking about my case or the earlier case, my lord.
Hey, obviously, item number 42 has been called and he is talking about your case only. That's the impression we got. Don't permit. There was one counsel who said that additional AGB heard before me, and you remember? Remember? Then he thought that probably I made a mistake by relying on additional AG's appeal. Don't do this thing.
Wait, please, my
So
lord.
this all, this thing at this thing.
Challenge, my lord, is to an amendment
That
in
it
the
can't
rules.
be heard for, this is all pending, Mr. The
Yes.
petition is admitted for
Yes.
hearing.
We filed our counter.
Learned counsel for respondents pray for and are granted.
File counter.
We are granting them time.
University has filed.
State,
Three,
my lord, the
three
amendment.
weeks time to enable them to file counter. This is NCCA certificate, madam.
Yes.
There are several petitions. Give the number if you can, Mr. Prabhakar Rao.
1 and 3, my lord, need to file count.
Huh?
Respondents 1 and
Give the number of the university and number of the rate petitions. Please give so that it can come up.
State was directed to file an affidavit, additional affidavit with regard to allotment of 2 BHK houses. But I have
You told us that it has been done.
But I have filed an additional affidavit. I have filed an additional affidavit, my lord, yesterday, my lord. Bringing to my lord's notice, my lord, about 65,538 houses have been allotted.
65,000?
538 houses have been allotted as on date. But, and also as on 3/8/2023, my lord, GHMC has a plan of allotting 65,458 houses in a phased manner. I have also filed it next year.
Where is that?
But page 19. if your
Additional
lordship-
counter, no?
Yes. Page 18, my lord, if your lordship goes to page 18, but this is supported by an affidavit also filed by the authority. Page 18, if your lordship sees, my lord, the number of houses which are in total.
So you are not a allottee, right, of BHK house?
No, I'm not. I'm in the pill.
That's right.
No.
So it is not to be opposed like an adversarial litigation, right?
No.
Effective approach. It has to differ. It should be discernible from the moment it is the case is called. When senior counsel started something, you wanted to interrupt.
Yes, no, I'm sorry.
That's why we asked that, are you allottee? It has been allotted to your people?
No.
Not yet. People who have set you up, have they been allotted? No. No. Mister, you must find out who are his beneficiaries and whether they have to be allotted or not.
Not my beneficiary.
You have persons who have set you up to fight this litigation.
No. As on date of filing, may I permit you to submit this, Your Lordship? As on date of
Mister, that's what we said. It's a public interest litigation. Adversarial approach is not required.
Yes.
Senior counsel is assisting with figures.
Yes.
All this purpose of intervention to stop him was only to drive home the point. You are doing the same thing.
Sorry.
We will substitute you by another amicus if you continue like this.
No, Your Lordship. I'm sorry.
Once everybody, it must be clear. Once we take cognizance of public interest litigation, you lose your locus.
Yes.
You don't control the proceeding. And if you, in our opinion, don't cooperate, we will substitute you by another senior counsel. We will ask him to address us as amicus.
Okay. Beg apologies.
No, we are telling you, you have not done nothing to this thing, and we are not interested in your apology. But we are telling, yes, Mr.
Page 18, if your lordship sees, page 18.
Yes.
But I've given the list of districts and the houses which are allotted as on date. If your lordship go to page 19.
No. So how many this thing, Mister, have to be constructed under the? You gave us holistic figure. How many houses, double bedrooms are to be constructed?
Then I take my lords to page 5 of the affidavit.
Number.
Page 5 of my affidavit. Page 5.
Additional affidavit.
Yes, additional at para 7. May I just read this minute from the
Yes.
I respectfully submit as on date of filing of the writ petition PIL number so and so 12,656 houses completed houses were allotted to the beneficiaries as against 1,87,000 completed houses. Now there is an improvement in the completion of houses. Allotment of double bedroom houses as on 1/8/2023 65,538 houses completed houses were allotted to the beneficiaries as against total completion of 1,43,544 houses. Further, it is respectfully submitted for allotment of houses. All 4 to 37 respondents are continuously taking up selection of beneficiaries as per guidelines in villages, wards where 2 BHK houses for which infrastructure is completed.
No, but this we believe is under some project, right? Some scheme.
It's a 2 BHK scheme, my lord.
2 BHK.
2 BHK.
So, like, how many houses you have to allot under this scheme?
It is phase wise, my lord. Phase wise, my lord. Depending
So
on
this
the
is what
beneficiary.
phase 1.
Yes, different depending on the beneficiaries in respect of each area.
All right. So
I have,
number of beneficiaries not identified,
Yes,
but
sir.
it can, anybody can apply. You will examine.
depending on
and
the social status and the financial.
obviously BPL and all that water.
But they are guided by the several GOs. But if your lordships now immediately go to page 17, I am referring to.
So out of how many you have allotted?
As on date, 1,43,544 houses are under completion. Allotment is made in respect of 65,538, which is completed and handed over.
1,43,000 are completed.
Yes.
And 65,538
are completed houses allotted.
Allotted.
In these districts of the state of Telangana.
All right.
But out of this, my lord, if you brought to my lord.
1 minute. So, so how many applications are pending for allotment of, how many houses are vacant, if you can tell us?
But I'll again subject to what, but I'll just take you, my lords, to the list, but just to clarify at page 18, if your lordships.
Yes.
Last column, 33rd column, my lord, I just wanted to point out this. In the GHMC area, my lord, 4074 houses were completed and over out of the 65.
You know what? Page 18, where do you get?
Last item, 33 minutes. 4,074 houses were completed and over. This is forming part of 65,000. Subsequent thereto, my lord, if your lordship again go to the page 5, the previous paragraph, my lord, I'll just read it for my benefit, my lord. Okay, para 6, my lord. The GHMC is again taken up. I respectfully submitted with regard to the GHMC area, special drive is taken up for allotment of further 65,458 completed double bedroom houses within 3 months. But that 3 months period is indicated in page 19. Page 19, if your lordship now go to minute. Phase wise, phase 1, 4074 is allotted. Phase 1. Phase 2, my lord, in first week of September, they are likely to allot 12,275. This is the now the present status, my lord, as on date which
page 19 you are referring to. Schedule of allotment.
Yes, sir. This is a schedule of allotment. In a phase manner, they are going to allot. Right? These are divided into 6 phases.
So,
as on date information which I am placing before my lords.
All right. So by first week of November.
Yes. This is the latest report.
Latest.
Total beneficiary that my lords have put it.
What was the grievance in public interest litigation that you are not allotting houses?
Then my lords had directed me to file a fresh report, status report, as to what steps you have taken. So this is the improvement depart from the earlier date of hearings.
When is the order directing you to file the compliance?
Well, this order is not. This is actually order proceeding sheet.
Oral observation. No.
It is recorded. I've seen that.
In the order sheet.
Direction is issued to the special government leader to file the present status report.
So can we have the date?
But I don't have the.
It's not readily available. Okay, fine. We'll see.
So I'm just bringing to my lord's notice the last date.
1st of August, right?
2 months. Yes. I had sought time to file this report. I had sought time to file this report.
Status report 25th April.
Yes.
25th April 22, Mr.
Today, as on 3/8.
No. Yes, there was an order on 25th April 2022 asking you to file a status report.
Thereafter, I had sought time.
Correct. But order is 25th April. Yes. And thereafter, you had sought time. Even on 1st of August, you had sought time. Correct.
Your lordship, please to grant time. I have filed the present report. But this is the status as on date. Okay. But I will further update the court with regard to the details of beneficiaries still left over.
When?
2 weeks here.
Yes, now. Anything?
Nothing. Just want to bring a lot of permits if.
Please. Constructive suggestion. Like this all. I mean, they have definitely made some progress.
Yes.
And all these figures, unless you want to dispute it by filing an affidavit, like
I'll file.
These are all incorrect.
Because I was informed by the petitioner that where they are not constructed also, they are allotting and showing it as allotment. In fact, that's what I want to bring.
Let there be an affidavit on this regard.
That's why I want to bring
affidavit.
I'll file.
Yes. In this public interest litigation,
File counters in this matter. I file counters.
You have filed? Yes. Only respond number 5. Others don't want. No, that's correct. But we take it that other respondents don't want to file, whatever. Then we will decide. That's it. Learn it. GP or revenue. Medical and health submits that he shall file a memo adopting the counter filed on behalf of respondent number 5 for
medical.
serious issue, right?
If we move on to file counter. They are not right. But the constant return of
The same order submits that he shall file a memo adopting the counter filed on behalf of respondent number 5 in respect of other respondents as well. Let this be done within a week. Same. Oh. You have found out that it's auspicious for you? Huh? A lighter vein, miss. You also understand.
The counter is sent for signatures in this matter, your lordship. It may be taken up after 2 weeks. Counter is sent for signatures, your lordship. It was
I am appearing for the petitioners. My lords, in this matter, there is a
counter.
It was sent for signatures, your lordship. It may be taken up after 2 weeks. We'll file a counter.
Petition is admitted for hearing. Let counter, if any, be filed within 3 weeks.
47 to 54.
Lordship,
What students is still waiting?
That's my lordship.
Not enrolled?
Not enrolled.
Because
there was an order from the.
Mr. You are appearing for bar council, right? Why keep these young people waiting?
But it is on account of the rules.
They have appeared in the examination which was held on 5th of April, February 23.
No, my lord.
The Bar Council of India Legal Education rules, particularly Rule 5, prescribe.
That examination has been held on 5th of April.
My lordship,
they have failed.
No, it is like they have not appeared because they were not enrolled in the bar, my lordship.
No.
Provisional registration.
They are not enrolled.
They are not permitted to get enrolled as a magistrate. The bar council. If they will get a degree, they can seek employment on the basis of the degree, but they have to entitled to this by getting enrolled in the bar council. Bar council rules provide that only if you complete the regular mode only, they will be entitled to enrollment. Bar Council of India rules.
So you are saying that this requirement of completing the course in a regular mode is mandated by Bar Council of India rules.
Quite true.
Then you have to challenge those Bar Council rules. How can you get away with a direction?
No, my lordship, as per the rules, what the Learned Council is saying.
Which rule?
5A.
The Rule 5 of the legal education rules. But for the sake of completeness, may I request the lordships to kindly take
legal education rules, right?
legal education rules, Rule 5, my lord.
Where is that? Rule.
May I request your lordships to take WP 46145, the pleadings are complete.
WP,
May I pass on a copy of the
Before that, may I read the rule, my lordship, with the permission. The rule says,
We are just trying to understand the controls. Of course, you will be heard. It can't be that order will be passed without hearing you. You can't do it. Especially when you are a budding advocate, like waiting in the wings. Huh? You are ready, we believe.
Yes.
Huh?
Yes, my lordship.
Ready, no?
Yes.
Yes.
May I read rule 5?
Please.
After P, the explanation appended. But in the book I had passed on, it is at page 57. I'm sorry, not 37.
Yes, explanation.
May I read?
Please.
But the entire controversy revolves around this explanation at the foot of the rule. I will read the proviso and thereafter the explanation. But provided that applicants who have obtained +2 higher secondary pass certificate or first degree certificate after prosecuting studies in distance or correspondence method shall be considered as eligible for admission in the integrated 5 years course or 3 years LLB course, as the case may be. This is the proviso. The explanation, may I read the explanation. The applicants who have obtained 10+2 or graduation, post-graduation through open university system directly without having any basic qualification for prosecuting such studies are not eligible in the law courses. But this explanation, the proviso and the rule itself has been subject to interpretation by various high courts, including our own honorable high court. The decision.
Who are these people? Petitioners?
But the petitioners are persons who have prosecuted their degree course in the open university.
LLB course?
No, degree course.
Degree
BA or the BCom course by open university. Without having basic qualification, that is +2, they did not have the intermediate to prosecute the degree course. They prosecuted degree course on the basis of an entrance test or an eligibility test conducted by the open university. And thereafter,
yes,
they prosecuted their law degree in the regular college. Now their complaint is that the proviso permits us to prosecute our degree in open university method. We can't be prevented from enrollment. But this was in fact the subject matter of a division bench judgment of our own High Court minute, which is filed in that WP 46145. But in WP 46145, it is at page 26.
Page 26 in?
I'm sorry, Vinod.
There is only 22 papers.
No, Vinod. The writ petition.
Which one? Please tell us.
46145 of 2022.
Oh, 461.
Give the record.
No, which writ petition the papers or pleadings are complete?
46145 of 2022.
49.
Serial number 49. Next matter, third matter.
So your stand is they are not eligible?
Yes.
Huh?
Not eligible on account of the rules prescribed by the legal education.
They can't be registered as advocates.
They cannot be enrolled as.
Enrolled, sorry. enrolled as advocates, correct? This-
Right.
And no relaxation, one-time measure, nothing.
Milord,
And
Some-
we are, I mean, like,
some of the petitioners, although not before in this batch, some of them had completed their degree course after filing writ petitions that they must be allowed to prosecute their studies. That also was the subject matter of the division bench judgment, Lord, which I am now adverting to or pointing out to your lordship. But at page 26 of that writ petition, the division bench of this honorable court has dealt with the very same issue and categorically held that
not
there is-
entitled.
there is no entitlement.
No.
Same is the
Page.
But the judgment starts at page 26.
So according to you, this issue involved in these petitions is not, it has already been adjudicated by division bench.
By the division bench, the petitioners are trying to distinguish on the ground, saying that was a matter which dealt with admission to the course. Now we are dealing with enrollment.
But same rules and all that, right?
My respectful submission would be if a candidate is not permitted to prosecute a course, Lord, your lordships may kindly come.
Which is the Bombay High Court judgment of His Lordship.
But Bombay High Court only said that Bar Council had power. But to my limited knowledge, no court has said that people can be enrolled in spite of prosecuting a degree course by an open university. In some of the cases, the courts have extended the concession to persons who have already completed the course, but that was before the promulgation of the rules. At page 45.
There is the rule interpreted. Rule. This is the case of admission to LLB course.
Quite true, Milord. Page 45, para 14. Merit. Keeping in view of the rules of legal education, this court is of the considered opinion that the petitioner has not fulfilled the eligibility criteria for admission into LLB course, provided under the legal education rules framed by the Bar Council of India, in exercise of the powers conferred by the Advocates Act, and therefore the petitioner was not entitled to admission into 3-year LLB course. It also dealt with the enrollment, but to the extent of the petitioners who were
See, Mr. The question of interpretation of Rule 5 in that sense did not arise before division bench because division bench was dealing with a matter pertaining to admission. Now you say that in view of Rule 5 explanation, they are not entitled.
No, let it like Rule 5 explanation. Rule 5 explanation dealt with the eligibility criteria for admission into a particular course.
Where is the rule? This eligibility for admission.
If a person who is not qualified or permitted to have the eligibility to prosecute a course, but in my respectful submission, it would be unjust to state that he is entitled for enrollment. He is not entitled to even prosecute.
So, but how have they managed the completion of course without being eligible?
The Bar Council of India.
No, just like
I'm clarifying. But the Bar Council of India, pursuant to the directions issued by the Madras High Court, has communicated to all the colleges that you take admission of candidates, clarifying this that you will not be entitled. They have done so. In spite of that, institutions have admitted them. And these are
on the date of admission, they knew that we are not entitled.
It was not
let us,
it was
so
not
let us complete the course, then we will challenge.
Then we will see.
So, Mr. Have you validity of the rules have been challenged?
Rule 5 validity.
Rule 5 challenge in this?
Yes, my lord.
Huh?
As per yes.
No,
As
no,
per
I
my
will challenge the rule 5. Please
yes, my lordship.
understand.
That's the issue here. As my friend had read out the explanation.
46145.
My lord. I am reading from the rules, legal rules.
But this
Legal rules of 5A. 5A. In the Provisco, I am reading the Provisco. Provided that the applicants who had obtained +2 higher secondary pass certificate or first degree certificate after prosecuting studies in distance or correspondent method shall be considered as eligible for admission in integrated 5 years course and 3 years course as the case may be. And next to that is the explanation, my lordship. The applicants who had obtained 10+2 or graduation or post-graduation through open university system directly without having any basic qualification for prosecuting such studies are not eligible for admissions in law.
No. So just a minute. So
yes. Sir.
Proviso says that the candidates who have obtained +2 higher secondary pass certificate or first degree certificate after prosecuting the degrees in distance or correspondence method are entitled for admission to LLB course.
Yes.
Where is your 10+2 certificate obtained in distance or correspondence method?
My lordship, all the petition.
That's what he told.
Yes, my lordship.
Just listen. It's not like we are trying to understand the controversy, right? The Laureate Council said that you don't have, that's the problem. You don't have plus 10.2. Without 10.2, you have done a degree through Open University. That's the objection.
Yes, my lordship. All the petitioners have filed their 10+2 certificates.
Oh.
All the we are not falling in the category of that explanation. Yes, right.
Mr. Yes, then things are different.
It is not so, my lord. Your lordships may take any writ petition.
Yes, my lordship.
One by one.
Petition number 50.
No. So you are saying that all petitioners have
Yes,
this
my
thing.
lordship.
Which petition? First is
1290.
1290.
I have filed a memo with the certificates. 1290 memo I have filed on 4th.
Mr. Shall you examine this?
No, he is
individual. Wait.
Subject to your lordship's concurrence. Lord, may make a table of all petitions and
that's what we are saying, that please examine this aspect, because we are not, you are also not taking it to be an adversarial litigation. They are young people, they will be very jittery. So, but we understand that how it is to be dealt with. So, you have rightly pointed out, we appreciate that you prepare a chart, find out, because your main objection is, as we have understood, they have not obtained +2 examination in from this thing. They have not passed, and therefore straightway they have obtained this
quite
thing.
good. I'll undertake that exercise, prepare a complete tabulation of all the writ petitions.
So supposing, we subject to further hearing, supposing if they have passed, such of the candidates who have passed +2 examination, as they are able to show, then in that case, are they eligible?
The Madras High Court has said no.
What do you say? We will decide. But you only told us that they don't have +2.
That is what the rule says, my lord. I have read the rule.
No.
Your lordships have rightly pointed out, I am not considering it as adversarial.
No.
As a matter of fact.
Correct. We appreciate that. So, but that's what we are saying, that if they are able to demonstrate that +2 examination they have cleared. So, what is the consequence in law? Not like trying to extract admission from you. Don't think like. So, like if they passed 10 +2 examination, the consequences, they are eligible in law. Correct?
May pass on, so that at least this.
No. What is it according to you? This will as of now, prima facie.
The full bench of the Madras High Court has clarified that a regular course can also be conducted by an open university.
No. +2 higher secondary in distance or correspondence method.
Yes, my lord.
So supposing if they have done, just a minute.
+2 or degree, first degree.
So +2 examination, if they have passed in distance or correspondence method, they shall be eligible for admission to 5-year or 3-year LLB course.
This short issue at rest may pass on without the full bench judgment of the Madras High Court. Only read 2 paragraphs.
We will hear you further, right?
Statement we need. When did they pass 10th? When did they pass inter?
Yes,
Whether
I'll-
those
I'll-
was also through open.
Remarks as to what is the prohibition or what is the impediment that is standing in the way. But this
Heard on the question of admission. Learned counsel for the heard on the question of admission. The didn't volunteer. He is more than willing to do your part. It is for you.
I have submitted the certificate.
Subject to your lordship's leave, your lordships have the petition bundle in your lordship's hand. 46145. Petition. Your lordships may kindly look at the index, my lord. It is filed by the petitioners. The first is the copy of the bachelor's. P1 is copy of bachelor's law certificate, copies of the email, copies of payment receipt, and copies of degree certificate. From the index, I also now go back to their application forms.
My lordship, I have last month on 4th, I have submitted all the certificates, my lordship. By a way of memo, I have submitted for each and every
No,
petition.
Mister, if you are unable to point out right now that you have passed 10+2 examination in the regular mode, your petition will be dismissed. We will look at one by one.
Yes, madam.
Give others can relax his petitions. He is very eager. So, Mr. Counsel, we will. If he is unable to produce the documents, his petition will be dismissed right away without giving an opportunity. Don't seek time thereafter to say that no, sir, I be granted time. He is more than willing to do this exercise for your benefit. He is not opposing you, like they welcome all. So they are not opposing you. You don't do it. And if anybody is doing, then you create hindrance in his part. This is what is the attitude, Mr.
Apologies, my lordship.
Okay. Which case?
1 to 9.
We go ahead. If he is unable to point out his petition, Mr. will be dismissed right away. This will along with this order. 1290. Which cases you are appearing?
1290. Item number 47, 48, 49, 50, and 50.
47.
48. 50, 49, 50. 49, 50. And 52.
52. 1, 2, 3, 4, 5. First one. Yes. Which page?
Memo I filed separately, my lordship.
One page. Where is
Memo 1290.
Satyavati? Srimati Satyavati. Where is she?
The second page of the memo is the 10th.
Which memo, madam?
No memo was served on them.
There is.
Your lordships may kindly take the writ petition papers. I will point out that.
Other than the writ petition, I have given him the memo also, my lordship.
This is what is called youth and inexperience.
No, my lord, my learned friend.
We don't want to penalize their their parties for the inexperience. His experience, but he's inviting it. What can be done?
No, my lordship. Apologies.
I was only trying to simply.
Why are you interested in wasting the time of the court? Time and again we have told.
Trying to bring it to the notice of the court that we have already submitted the document.
Please supply a copy to him. Let him also. If they have no case, he will be more than glad to concede before this court.
Yes, my apologies, madam.
He is taking the trouble for you by preparing a chart. Like, why should you? Nothing will happen in 10 days, right?
Sorry.
What, you will be put to great financial loss, right? In 10 days, you will earn 100 crores.
No.
Mr. Bar Council. Every day is.
I can't comment on the.
No, every day is 10 crore. Petitioner is losing 10 crore every day. 10 days means 100 crore. So you must act in this all good humor.
I really pray that all advocates
we
have that kind of.
We only want that you should enjoy the humor part. What like this we are trying to find is inexperienced person. He is saying everything, but we want you to enjoy the humor. That's it. So that's his point of view. He is impatient because 10 crore every day. Mister?
Sorry, ma'am.
So 4 cases, 2.5 CR per appearance, 10 crore. Straightway he will be, Mister, you should not only enroll him, but enroll him straightway as senior counsel under section.
Once again the rules come in the way there is a requirement of a 10-year stand.
That's what it is. Senior counsel. And bar counsel should engage him and pay him 2.5 CR per appearance. So when do you want? Yes.
10 days.
10 days. When? Tell us date. 19th would be an ideal day, mister. So that from Monday you can start recovering fees. Huh? 19th August is a
Working Saturday. Working Saturday.
But not on a Saturday if it is not inconvenient to your lordship.
No, Saturday would be ideal, right? Like, I mean,
Because we also have little tentatively free board on that day.
I leave it to you.
we quite appreciate that, but you will have to take trouble for these young people who are waiting.
But it is no trouble, Melody. It's a part of.
Lighter means. So 19th.
I'm deeply obliged.
Obliged.
GP for home, GP for revenue.
Item 55 appearing for one of the non-official respondents.
Yes.
We filed our counter also.
Yes. Respondent number 9.
Respondent number 9, my lord, filed the counter.
You are filed.
Respondent number 3, GHMC seeks time to file counter merit. Respondent number 3, GHMC seeks time merit. Though a formal counter is filed by respondent number 6 who is deputed.
Let them file.
Deputed with us regarding
Let
action taken. Regarding action taken.
This is for protect. You are filed, no? You have to. So learned counsel for respondent number 3 and 4. Pray for and are granted.
2 weeks.
2 weeks time to enable them to file counter list thereafter. Weeks time.
1 week time. 1 second. This is challenge to GOMS number 3. Dated 23.
Petition is admitted for hearing. Learned counsel for respondent prays for and is granted 4 weeks time to enable her to file counter.
GP for revenue.
10 districts and not 33 districts.
Might please, Mila.
Yes.
This is a petition against the order of.
Madam is not answering anything. She doesn't say anything. Whenever we have asked her many times that section 12 has been interpreted by Supreme Court, she says that her senior is somewhere and has not got back to the High Court till today. We don't know where is he. And every time the case is called, she smiles and doesn't say anything. Every time we tell her section 12 is interpreted by Supreme Court, Human Rights Commission has no power, she say, I pray time. Ask her what she is going to say.
Instructions requesting time. Requesting time minutes.
Why? Read section 12 of Protection of Human Rights Act as interpreted by Supreme Court. Madam, order. We have already held.
One case we already questioned.
One case we have quashed out.
Milords,
You have got the copy of the order?
Yes.
Passed by us?
Yes.
Please pass it on. So, madam, no time. And in any case, you are not a contesting respondent fighting for anybody else. You are a Human Rights Commission, right? How does it matter if it is quashed or not quashed? How can you issue an injunction that not to proceed with the survey?
Lords, we have already informed that not to pass any orders without jurisdiction, Lords. We have already instructed HIC to not to pass any orders without jurisdiction, Lords.
You have told, no? So you concede that it is without jurisdiction.
Yes, Lords.
You are sure about it, madam, what you are saying?
Yes, Lords.
Sure.
Yes, Lords. It is actually a land dispute, Lords, wherein the HRC has ordered stay of certain Lords.
Correct, no? Then this is what it is. The legal position is like that.
Yes, my lords.
and you are not contesting, then why should you seek time? Heard. Heard on the question of with consent of the parties, matter is heard finally. In this writ petition, petitioner inter alia has assailed the validity of
Counters not fair.
their counter is awaited, they are not praying for time, we will grant them time. Let counter if any on behalf of respondent.
We have complied the directions of this normal code in fill my order to form
No.
Gram Panchayat. We'll file our counter.
See, Mr.
Last time also.
13/6/2023, there is an direction by division bench, let respondents file counter affidavit within 6 weeks. You say, I don't want to file.
We are filing, it is ready, my lord, counter, just we have to file it, finalized it is.
We did not ask you whether it's ready, finalized, why it has not been filed. Simply time. Can you not say that I want 3 weeks further time to file? Why is it so difficult, mister? What really prevents you? This is now my 3rd week here.
I'm sorry, my lord, we'll request time.
See, mister, we are not here to extract an apology from you, right? We have been telling that please say that I want 3 weeks further time, 4 weeks, whatever. Just standing up, you are saying complying with the directions PIL, we will decide then. The consequences will follow of non-filing counter. He will say he stood up, didn't say anything, and it amounts to, and said that he has complied with formation of direction with regard to formation of PIL.
I request time for filing counter, my lord.
This you could have said, no? In the beginning, first sentence itself. Learned counsel for
GP for Panchayat. GP for Panchayat Raj, it's time.
3 weeks.
Order already complied.
Further time.
My lord, may I please, my lord?
Mr. Yes.
My lord.
Contract employee.
Yes,
right?
my lord.
Huh?
My lord, petition before lordship or
what happened to you? Did you find out what happened in Supreme Court? SLP is pending, no?
Yes, my lord.
What happened?
My lord,
We have deferred hearing. Madam, contract employees, yesterday it was listed.
Yes.
We have deferred hearing saying that SLP is pending.
My lord,
So please find out what has happened.
According to my client's information, my lord, the Honorable Supreme Court not passed any order in favor of against our Honorable Division Bench judgment.
It's still pending. We are awaiting orders.
My lord, awaiting orders, my lord, this Honorable, our Honorable High Court, my lord, Division Bench allowed the writ petition.
Allowed.
My lord, page number 70, my lord.
No, you have been inducted into service when?
2000, my lord, 1/4/2021, page number 47.
So, Mr. Mr. Rao,
my lord,
you should read the judgment of the division bench more carefully. After cut off the date, if you are inducted, you are not entitled to benefit. That's what they are going to argue. We are telling you in advance.
My lord, same issue, my lord, covered by this, my lord, unless, my lord, Honorable Supreme Court, not at, my lord, petitioners before lordship were appointed 1/4/2021. They were terminated, my lord, 26/3/2021, my lord. 2016, my lord, petitioners were appointed.
You have seen that, right?
My lord,
1 minute, we'll tell you.
page number 73, my lord, our Honorable Division Bench judgment. Same issue, my lord.
28.
Error 28.
Please see.
My lord. Yes, my lord. After formation of the state of Telangana, while adopting the application Act 2 of 1994, the state of Telangana, in exercise of powers vested in the government under section 101 AP Reorganization Act 2014, the government inserted section 10A into Act 99.
Similar issues are pending, therefore we will not pass an order. It has been deferred. Please, have you supplied a copy to the council for?
Yes, ma'am. Long back. Yes.
Very long back he has been. You know what has happened. You have welcomed him in Bar Association and assured him of best of your cooperation.
I'm sorry, my lord. At the time of filing the return, at the time of filing the writ petition only, my lord, we issued supplied the my lord.
So then you have to.
Same benefit, my lord. Lordship so pleases, my lord. My lord, same benefited maybe, my lord. May I request, my lord?
1 minute. We understand that division bench order is in your favor.
Yes.
And therefore you want its disposal today in terms of order passed by division bench. Correct?
My lord.
And you say that SHP has been filed, no interim order has been passed saying the order passed by
Yes.
division bench. Therefore,
Same benefit may be, my lord.
no, but Mr. How will you defend this order in Supreme Court? They will challenge it.
So
They will say, no, they will say that we have not been heard by the division bench of the High Court before passing the order.
I'm sorry, my
Nobody is
lord.
appearing. Mr. The counsel to whom you had supplied a copy of the petition has come to this side. So now we are trying to ascertain, we have to seek their response. No, we have to hear them. No? Even if it is to be allowed, they have to be heard.
Now, my lord, earlier, my lord, now present Honorable Judge Anil Kumar was appeared.
That's why we are saying, we will take it up in this. We don't know, office is directed to reflect the name of the counsel, learned counsel who represents.
Filed an affidavit on behalf of respondent upon event. But this is in respect of Hillfort Palace, which is a heritage structure. point.
What?
Hillfort Palace.
Yes, which is the oldest structure. Popularly known as the very neighbors are often dealing with such a protected structure, but nothing is being done. Lot of litigation surrounding that really created left untouched. No maintenance, nothing. If we go to the central exchange and entrance at the building, from there you can see walls are falling apart. Very bad structure. But
You represent the government, right? Today we came across an interesting thing. Your employees of the government, state government, they are attending their offices and wearing helmets. So, you don't need our direction to do or to secure safety of your employees. It's a unique thing, Mr. Employees sitting with helmets and the roof office and in the fear that roof may fall on their heads any point of time, Mr. A special GP, you will look into the matter on your own, right? You don't need this thing, direction by us every time. Though that is not the subject matter we understand. But I just reminded of this dilapidated condition, so we just reminded of that very interesting photograph for employees sitting with helmet.
I've also seen.
Seen, no? Advise the government. Yes, so what is, you have filed affidavit?
Yes, today I filed an affidavit, but we have put it to the National Academy of Construction to kindly advise us in regard to the structure, stability of structure, and also whether we should proceed with the removal of structure or reconstruct. But that request of the state is pending with the academy now. I filed an affidavit.
Who appears?
Academy minutes, earlier state was representing, the report has been filed. But we have addressed to the competent, persons who are expertise in this field. I have said so in the affidavit. The Lordship sees, kindly see para 5 of my affidavit which is filed. Pursuant to the earlier directions of this court.
Para 5.
Para 5, no?
I submit.
This respondent has requested the National Academy of Construction.
No, this what is given to us is begins para 5 like this. I submit, I have addressed the letter dated.
Yes, sir. Yes, sir.
No, 1 minute. I don't have what. 9/8.
This is filed on 9th of August.
Okay. Yeah. Yes. Yes.
May I read minutes? I submit that this respondent has requested the National Academy of Construction while letter dated 24/7/2023 to clarify whether the reconstruction will be taken up by demolishing the whole existing building or reconstruction is partially required. The clarification by NSC is necessary for taking a decision in this matter. At that stage, the matter is.
Academy.
But this is an authority which is acting under the instruction of the state. We are waiting for the report has been filed by the authority.
You can't say that. I have sent one letter from one wing to another, one room to another room, and I am waiting.
But they are the experts in the field, my lord.
No, but they have to take a decision, Mr. And you will inform within how much time?
3-4 weeks, my lord. But this will take some time, my lord. This earlier report is in great detail, my lord, that we cannot actually proceed with the construction because the structure is in a very bad shape.
Yes, Mr. Let it be examined, right?
Yes,
By an expert. Mr. Special GP submits that in compliance of the
child in base of the particular fact of the order to it was the only which served as a leading 5-star details and one. It is a regular Fortunately.
Classification methods. The action was given to file a better application. Response.
So what is, I mean,
But this bill is filed.
you are petitioner, right?
Yeah. Response.
Milord, I am the petitioner. Yes, Milord. See, this Milord, in fact, is so going that I honestly come before your lordship. This has been filed, this petition has been filed during the rainy season when the crops were completely dead in the month of April 2023.
Without approaching anybody,
Right.
away to High Court.
Yes, Milord. That is the reason that at that time, at that point of time, actually, this bill was filed.
You approach somebody, find out what has been done. We are dealing with flood relief measures in another public interest litigation,
Yes,
right?
Milord. Yeah.
You find out, do some this thing groundwork, Mister. This not like if you are an activist, you are go to bed at 10:30 and morning 8:30 a.m. you draft a petition, 10:30 file it before the court, seek a mention memo and say that I have filed till. We can put you very inconvenient questions which I am sure you will not be able to answer.
No, Milord. In fact,
Like, so this is like,
even the government,
as brother has pointed out, you have not approached any authority. Like, is this the way of doing anything? Like, and who are you?
see, Milord, I am the social worker.
No. So everybody is a social worker.
Anyhow,
You, in a sense, you are also a social worker, right? You do something for the society
Milord,
in your spare time, right? When you do a case without charging any fee from the client, right? Some cases you must be doing. You are also a social worker rendering service to.
Milord, in this case, a limited because I request your lordship.
See, He appeared today before us, the petitioner.
Yes, my lord, in the majority of the bills, in fact.
Yes, he petitioner asked him, he appeared in one case.
In this, my lord, I request your lordship, it can be disposed of. The only thing is the government.
This thing,
my point
you
is
approach some authority. So there's two like this thing, two general and this thing.
No, here is the, see, the government has come in time. There are so many guidance have been given by the government. Only the time the officials have not just.
What I mean, see, Mister, you must this thing tell us to whom the benefit has not been granted as per government guidelines. What is the information? Do something. It's not a like file a petition, then fact finding inquiry. The court will gather facts for you. Huh?
No.
What have you done? Have you at least tried to find out that these many persons were affected in the April rains and these many persons, only a few of them have been granted relief. These are the person, according to my information, not afforded any flood relief material, whatever, not compensation for damage of crops. We cannot conduct an inquiry, roving inquiry in a public interest litigation.
Yes,
please understand.
Yes, oblige.
You do it. You file a better affidavit, come with data. We are not saying that farmers are not entitled to compensation. Of course they are. But when you do this, take upon yourself, you have to act very sensibly. Not like just saying filing.
Definitely, sure. Just I oblige your lordship. Because this at the point of time when I filed that the data was not available because the people just what was this a different as your
now data is available, right? Find out.
As your lordship.
Find out. You are an advocate. Find out under RTI Act what are the guidelines. You tell us, see, Mr. This is all. I mean, it is not. You are not fighting against anybody, right? We will not permit them to contest this litigation. But there has to be some data. You tell us that these are the guidelines in case the rain affects the crop of persons. These are the guidelines under which they are entitled to these benefits. Then you say these guidelines have not been the benefit of the guidelines have not been given to the farmers in the state. Once we have the data, I will ask definitely. We are not throwing you out. Please understand.
Definitely.
You have to make an inquiry, support your claim. Must like we will not conduct an inquiry here in a public interest litigation. If we start Mr. testing all the PILs, it will be very difficult. 99% the experience has shown that they are frivolous, motivated, sponsored, everything. This is a genuine public cause. We are saying this falls within 1% exception. But you must guideline obtain under RTI. Tell how these farmers the benefit does not be. We are sitting here. We will do it. Learned counsel for the petitioner, who is a practicing advocate, has filed the public interest litigation seeking
But I appear for response 6 to 10 minutes. But 6, I file my counter. 7 to 10, I seek 2 weeks time.
Huh?
Respondents 2, 3, 4, and 5.
You have filed.
So not permitted to file the counters within 3 weeks.
Oh,
And for the respondents 2, 3, 4, and 5.
2, 3, 4, and 5. 4 weeks.
Deep level.
Grace warrant is granted 4 weeks to enable him to file counter.
I appear for the respondent writ petitioners, my lord.
I appear for the appellants, my lord, for the state. So request 1 week time for the final hearing, my lords.
Final hearing, this is IA.
Interlocutory applications have been filed for the direction petitions.
Petition.
Vacate stay.
1 of 2020.
Stay has been granted in the favor of state.
Judgment of the learned single judge was suspended at the time when the writ appeal was admitted, my lord. Now it is coming up for hearing.
Vacate petition. You have filed.
I have filed vacate petition. My writ petition was allowed by the learned single.
I'm appellant in this, my lords. I have not filed the direction petition. I was just seeking adjournment, my lord.
Why? Senior counsel is saying that he has filed a vacate petition.
My lords.
Long ago.
At least you should know the reason. Mister, you should at least know the reason. Why do you want an adjournment? You are looking at us.
No.
We will not invent the ground for you. Why do you want an adjournment?
For arguing this IA petition, my lords, my special GP will be appearing in this matter, my lords, so I just seek 1 week time, my lords.
You should be fair to these people, senior counsel. If you had told them in advance, they would have gone home, right?
Have not in
At least be fair to them.
Have not in.
As a this thing, these are courtesies, basic. You must extend to these. They would have gone home. They are waiting for this case. And when case is called at 4:20, you say, I want adjournment. Tell them.
Sorry, my lord.
Yes, Mr. What date?
Any day. Next
You
week,
will
any
have to
day.
argue on, this is not for hearing, this is on vacate, this thing, vacate petition. We will hear it on that. Every case can't be heard finally.
My lords. Next week, any day.
Saturday. Saturday. Little inconvenient for you, but you will come.
I will come, my lord.
Because it's a working Saturday.
Working Saturday. Yeah. At least in first half, all of you will have to be available. And we expect that we take it up.
Once availed the extra holiday, we have to work on Saturday.
Mark the presence, learn it. You are who? What?
I'm AGP.
AGP. Praise for adjournment to enable him to prepare the case and argue IA 1 of 22. Let the appeal be listed for consideration of aforesaid IA on what Saturday? 19/8/23.
Deeply obliged.
Yes.
May I please? I am for petitioner.
Petitioner?
I am petitioner.
Appellant.
Petitioner. Appellant in the writ petition. Appellant in the writ appeal.
That's what it's an appeal. There is.
Yes, I'm sorry. Lord, I am just,
What?
I'm just passing the brief events of dates, Lord. Hello. Hello.
We thought that you are moving a memo seeking leave of the court to withdraw the appeal. It's your petition, right?
I filed vacate stay petition.
Also, then you should argue, right? He is arguing. You don't want to argue your
No,
vacate.
I'm ready to put.
Then you should say it's my petition.
Yes, my petition. Asked by this honorable court. In counter at page number 17. In a writ appeal filed by the appellant. At page number 19, my lord.
What is the point, Mr.
Point is
Stay has been granted.
Yes, my lord.
What page 17, 85, 93? Why?
In
You are
2009, the 2009 land acquisition proceedings were initiated as per the old act in 1894. And the initial proceedings were initiated, and by 2012, compensation was paid and lands have been vested with the state. there was no dispute in respect of the acquisition of the land, taking over possession and payment of compensation. Thereafter, lands have been vested with the state. Well, this he came up with a writ petition to, since.
So you know, what is the interim order 11/7/23?
11/7 at page number 17, minute.
No. Division bench. What you are seeking vacation of order on 11/7/23,
Yes,
right?
11/7.
You are in a hurry to allot this land to an industry.
Not in hurry, millet.
That's why.
Yes,
Do you have the copy of the order dated 11/7/23, Mr.?
Yes, millet.
Please read.
Page number 17, millet. The order operate portion at 19, millet. Learned counsel for the petitioner, appellant and learned special government pleader attached to the office of the.
Said that's not relevant.
Yes, millet.
Admittedly,
this court by order 15/12/2022 in IA number 2 of 2022 in writ petition number 44,844 of 2022 granted interim direction as prayed in the application. While the said interim order is subsisting, the respondents have issued GOMS 5 revenue dated so and so 3/1/2023 by allotting the subject land for the purpose of setting up the palm oil industries complex to the private company in contravention of the said interim order, which act of the respondent on the face of it in contemptuous. Apart from the said approach resorted to by the respondent, the claim of the respondent before the learned single judge that the subject land has been allotted for the purpose of setting up of the industrial complex and the said GO is not under challenge, in our considered view cannot be accepted since GO issued itself is in the teeth of the interim order. Yes, learned single judge, the order that has been passed by the learned single judge when the writ petition came up for hearing at page number 25, learned single judge direct the respondent to dispose of the representation made by them. That is only order passed by them. In the appeal, this order is misconstrued in the appeal. It is said that only there was a direction to consider that application as per the direction granted by the honorable court by the learned single judge was considered and disposed of.
What? So his prayer for allotment of land, what rejected?
Rejected. Rejected, my lord. Since the lands have already been vested long ago in 2012 with the government, unlike that of in the new act, there was no provision to return the lands, reconvey the lands to the.
No, Mr. Just a minute. Petitioners filed reconveyance of the land requirement. Can we see reconveyance? In 1894 Act, there is no power only under the National Act. So then nothing. Yes, Mr. What is the provision? Which law permits you to seek reconveyance? No. Please understand. Which provision, statutory provision under 1894 Act permits you to seek reconveyance of the land once they have been acquired? Provision.
Provision, my lord, I relied on a Supreme Court judgment. And also, my lord,
Provision.
My lord, Supreme Court
won't enact a law for you. Which? So tell us which provision.
Lord,
1894. Your land was acquired under 1894 Act.
Yes, my lord.
Which provision you are entitled to seek reconveyance?
Lord, kindly, my lord, see page 164.
Consent award has been passed, Mr.
Yes, my lord, consent.
15/3/2013 compensation has been paid, possession taken over. Thereafter, nearly after 9 years, you file a petition seeking reconveyance. So naturally, the writ petition would lie for enforcement of a legal right. So which provision confers right on you to seek the reconveyance? Simple question.
My prayer is to. Yes.
The answer is either the provision is so and so, or you say there is no provision.
Provision is, my lord, under new act section 101.
New act doesn't apply.
Reading with, my lord, GO is also referred in the same prayer, my lord.
So then you should say there is no provision in the act. I am relying on GO.
Yes,
and simple, right?
Yes, sir. Yes.
Why is it so difficult, right? You understand what we are asking correctly. So you say that for claiming reconveyance, I am relying on GO and a decision of Supreme Court.
Yes.
Which tell us which GO.
GO, my lord.
New Act will not help you, correct?
Yes, yes.
Please tell us.
GO 79, my lord.
Huh?
GO 79, page 51, my lord.
51.
Yes. Right, my lord. This is also my lord, under old act only. My lord, they have reconveyed the lands to the other projects. But,
your case before the learned single judge was that under 2013 Act and under section 101,
this has been
you are seeking reconveyance. Now it has been dismissed, so you have switched over to GO, correct?
No, in the prayer, I mentioned the same GO. The prayer.
Learned single judge in para 3 says
yes,
petitioners filed taking aid of section 101.
Kindly see my prayer writ petition.
Where is that?
Petition 15, page number 15 or
We only hope that you have drafted your petition properly because today we learned that the reliefs were not claimed. 36. Yes. Is challenging GO arbitrary illegal. Read the prayer clause for our reference 36.
Sorry.
Page 36, Mr.
36, page. For the reasons stated in the accompanying government is there.
Forget about this.
Please to pass an order direction.
Read.
Particularly in the nature of the writ of mandamus.
Mike, take it. Mike.
I'm sorry. Particularly, my lord, in the nature of writ of mandamus declaring the action of the respondent not exploring the possibility to reconvey the acquired lands to the land losers, awardees and patadars, that is the petitioner say in as per section 101 of the Right to Fair Compensation and Transparency Land Acquisition Act, Rehabilitation Resettlement in 2013 and GORT number 79 dated 28/1/2016 issued by this Telangana government is illegal and arbitrary in violation of Article 14, 21, 300A of the Constitution of India, and consequently, this honorable court may please to direct the respondent to explore the possibility.
So you are challenging the GO dated 28/1/2016 as arbitrary, discriminatory, illegal, violative of Article 14, 21 and 300A in the petition.
Yes, my lord.
And now you are relying on that very GO.
Yes. My lord, twofold relief is twofold.
You understand, right? What? Huh? So we have found the answer to your petition.
Then next. Page 164, my lord, is a citation, my lord.
No, you understood, Mr. Poche, what is missing in your prayer?
Yes.
Not reconveying. The word not is missed. So what is happening is you are challenging the GO saying as declare it as illegal arbitrary. Please read your prayer now.
Right.
How casual you people are. How casual. What happens supposing if you are met with some medical emergency and the doctors like you, I mean, which you have doing like this performs a surgery on you. What will happen? So casual. You have challenged that GO in the writ petition. In writ appeal, you are relying on that very GO. Then you are referring to page 51. We have opened that page without referring to. You have gone to some citation. What can be done? You tell us. What can we do? Tell us, as an officer of the court, what can we do?
Lord, this is Lord, not seen by me also.
Huh?
Lord, I'm relying on one page, citation 164 also, Lord. Page 164.
With this judgment, where does it say under the old act?
It's old act.
You are entitled to reconveyance of the land, right? Supreme Court says.
Yes.
Which
I made, Lord, first.
This Royal Arcade I have dealt with in Karnataka. Yes. The different thing. I know what you rely, what which para?
The very first, my lord, the head note itself, my lord. The fraudulent exercise of the power of eminent domain, fraudulent diversion of the purpose for which the land acquired.
No. First page says whether land acquired by a state government at the instance of corporation for so and so resort at near Bangalore airport could be transferred by corporation to a private individual.
Yes. Now
that is not the question.
Now, my lord, they are alienated to a private company now.
That's why, Mr. Counsel, we made you read the prayer in the petition.
Yes.
Is this your case that they have acquired the land from me and illegally transferred it to somebody for this thing for a golf course?
Yes, my lord, in spite of the court order, my lord.
You have read the prayer, please. Again read page 36. Read it aloud. Read.
Lord,
again 36, para 36, page 36. You have read it, again read.
No, I understood that. I understood.
Then this is
said that it is contrary to the purpose for which it is acquired. You are now transferring it to this oil company. That is not your prayer at all.
What anything like anything you can argue without pleading this thing. In reply to application seeking vacation stay.
There was an order, my lord, but that order has been violated by the respondents. While subsisting the order on on 1/3/2023.
If you are entitled in law to file a fresh writ petition challenging the action of government in selling your land for a purpose other than it is required, was acquired, you can file a fresh writ petition. But in this, what can be done? You have read your prayer clause, right? You understand?
Yes.
You will have to implead all those persons. It will be altogether different, this thing.
Yes,
we will say only on a different cause of action if you are entitled to do so in law.
Already learned single judgment is given Millard to file a question the GO.
Not only GO, the purpose, everything, it is open for you. See, it was acquired for an irrigation project. Now it is being divested to some other purpose. You'll have to bring all the, where have you pleaded? Please see your writ affidavit, prayer.
You are seeking reconveyance under 101 of 2013 Act. This is the scope of the petition. You have read the petition, Mr. And you have challenged this GOMS as arbitrary, violative, discriminatory. 1421, 308.
Apart from that, Milord, there is another citation which I relayed, Milord, which is
this thing, Royal Arcades does not apply to your case. The issue involved therein, read first paragraph, page 167. What we are trying to tell you, if you don't understand the counsel, we are probably exceeding in advising you, which we are not supposed to do. Both of us has given that job. Despite that, brother is trying to tell you what should you do. If you don't understand, It's very easy. Just now you will get an order with certified copy today. Book your flight to Delhi. We'll try to deliver it before 9. She types what, the moment she types, I will sign. This intra-court appeal. This has to be dismissed, right?
Yeah, I will file a fresh petition.
You better withdraw this appeal with the liberty to file a writ petition on a separate cause of action.
Published.
This intra-court appeal has been filed against but the landowner is plight, but he has to be properly assisted, Mr. Please examine it and then file. What? This intra-court appeal has been filed against an order dated 23rd March 2023, passed by learned single judge in a writ petition, by which writ petition preferred by the appellant seeking reconveyance of the land, his lands acquired under the provisions of Land Acquisition Act 1894 has been dismissed. Paragraph. Learned counsel for the appellant after
Instead of his land, there are 33 petitioners are there. 33 petitioners are there.
Their lands. Their lands. Learned counsel for the appellants, after arguing the matter to some extent, submits that subsequent to the order passed by the learned, submits that the state government had acquired the land belonging to the appellants for
irrigation.
For irrigation purposes. However, contrary to the purpose for which the land of the appellants was required, the state government is now
alienating to a private company. Alienated.
Has alienated the land in question to a private company
under GOMS number 53.
GOMS number 53 of
3/1/2023.
3/1/2023. Paragraph. In view of learned counsel for the appellants submit that in view of aforesaid subsequent and read the relief twice before filing. These are poor people. Deal with their case with more caution.
Much obliged.
Huh?
The petitioner counsel got held up before another court, your lordship. Kindly post it to tomorrow.
No, this is 440, madam.
Yes, your lordship.
Which court?
She had to leave to another LB Nagar court, your lordship. Yes.
Huh?
Kindly list it to tomorrow.
Please. How long you are at the bar?
Your lordship, I joined 15th July.
15th July.
Yes, your lordship.
First thing you should ask your senior is, when you are before the High Court and that too before the first court, you should not say that your senior is stuck up in Rangareddy Court or some other district court. High Court is the High Court and first court is the first court. Please learn. Ask your senior that he did, ask him why he did not tell you this aspect. Huh? Please ask him.
Yes, your lordship.
Next week. Praise for it, learn it, write her name, learn it counsel for.
Next week, we'll put it next.
Praise for adjournment. 1:30, no, tomorrow till 1:30 this bench will.
I don't have.
Yes.
One second.
29.
30 and other in the 16. Monday is not possible. No, why not Friday? 18th.
That day, madam, don't make this thing, right? A similar request. Huh?
It's a Thursday.
Regular Thursday.
Huh? You tell that first court is very tough, doesn't grant adjournment, so I won't go. Huh? Or you ask your senior to permit you to argue the matter, right? And then argue, we will decide. Okay?
Right.
18th. So this 2005 AP study circle.
AP study circle, we have also given some the Supreme Court matters. These are Supreme Court matters.
What which should we take up? 72? We'd like to fix it. This is the thing that I'm finding. Mr. A, 2005 matter. 2005. Ready?
Ready. But it takes some time. That's subject to lordship's convenience.
No. What takes time? He has a very good case on merits. He will conclude in 5 minutes.
Let him make out my letter.
Facts you will tell or straight away Meher Singh? Facts. Where you were recruited, what happened? Huh? Assistant professor on
Public administration and HC.
which date? On contract basis or regular against sanction? Where is the order of appointment?
Appointment.
Where is the order? Page 3 is memo of appeal. This writ petition we have memo. Booklet. Acha. Material paper book. Yes. Page 3.
The state
Mr. This is read clause 3.
What is the issue?
So when your services were confirmed when? Extended until further orders. No. This 2000 appeal has come up before us after 18 years. So that shortly will come next 18 years. I won't be there for 18 years, right? Wish you all the best to argue before a new bench. So what happened? You should have again given us synopsis. You are waiting for such a long time to cut short time. Repeatedly we have told. Where is that then? Don't ask us to turn pages. You should have given one page. No. Where? Where? Material paper book. Ah. Oh. Ah. Yeah. Yes. Running index. Yes. Faculty members. Okay.
My son from extended. Joe, but now this Joe, we hear from this. Six. Six. The McDonald's issue. What's the document now? What? The result. The 1.3 is very tough. The required to extend. Let's say, you can supplement education 86. What's right today? I heard that. As follows. The sitting at the should by the client, it should approve. Secondly, for programs, we have devices. One from the speaker. Everything. Also, I be fine. Seven. Consequently, I have the cross. Let's start with after is accepted. Which is that both petitioners have a government statement is procedure. Truly contributing the selection committee. It's depend also, which was the selection committee. Which is selection to the except show president of the that's comes for a very comes for a social exceptional secretary to the PSC and the director of the PSC. So I had two experts. Yeah, we did that.
Yes. Yes.
Contrary to that, my government accepting these two provisions. That one the all Indian government which are applicable. State government pension rules are applicable. Subordinate rules are applicable.
Yes.
One issue. I mentioned something like 197. Because the implementation will active the government outside. We are the teachers. We will give coaching from the government from the training. This has to be These are the balance. And then the last one is 142. 140. I will not say important. Important. In the 36 paragraph. Why this is my name for these.
Yes.
Milan. It is a, they were at initial appointment as Len friend read out. At page number 3, my lord, your lordship, they were appointed on temporary basis. My lord, in the AP study circle,
Entitled to UGC pay scales.
they are not at great respect, my lord.
Order says.
My lord, the relevant provision of law had not been brought to the notice of the learned single judge when it was decided. Subsequent GOs have come here. Just your lordship, I invite your lordship's kind attention. My lend friend referred to GOMS 520 at page number.
No, Mr. Read para 1. You easily say no and all that. Read para page 3, para 1. Mr. Read page 3.
Page 3, my lord.
Shri
Ravi Kumar. Ravi Kumar is hereby appointed assistant professor lecturer, public administration, AP study circle on starting pay of so and so in the UGC scale of so and so, subject to the medical fitness and verification of
appointed in UGC scale, right?
Yes. My lord, they,
as and when it is revised automatically. Don't say no. We have seen it. We have shown us, and thereafter we are putting you a query.
Yes.
Not like whatever strikes to us.
This was a letter. This proceedings were initiated without the approval of the managing committee, and they were not appointed in a regular sanctioned post. There must have been an approval from the managing committee as per the bylaws. And further,
where have you said in the your counter that not appointed?
Yes.
Backdoor entry. Where have you said?
In counter.
You cannot make oral submissions, right?
138, my lord, your lordship.
Please. Where have you said? 138 is?
138, my lord.
Yes.
Paragraph 7 at 139, sir. It is, my lord, it is submitted that the government will sanction certain amounts from year to year toward the implementation of the various coaching programs, out of which the AP study circle will have to meet all the expenditure. The establishment and the administration, there is no specific component being sanctioned by the government toward the salaries of the teaching and non-teaching staff appointed engaged in the AP study circle and its branch. It is submitted that the post of teaching and non-teaching have been created by the managing committee of the AP study circle as per the convenience keeping in view the administration institutions. It is further submitted that on 13th September 1987, the director AP study circle issued a notification calling for application from the interested candidate for the appointment as faculty members in history, sociology, psychology, public administration, public science, Telugu and English to coaching services examination candidate of UPPSC. It is submitted, but both the petitioners have appointed as assistant professors on 1/12/1987 and 12/11/1987 initially in the pay scale of the 700 so and so, along with other faculty members for a period of 2 years. Subsequently, their appointment has been extended until further orders, while this office memo dated so and so have been continued as on today. Their appointments are purely temporary. As per the GOMS 520.
So where is the averment like that backdoor entry, no approval against sanction or not against sanction post?
Yes.
So far we have not found anything.
That is specifically not stated, but these posts have not been sanctioned. These are not regular posts. During the course of I am taking instruction, I am carried away by their oral instruction, but that I should not be exactly pointed out. Yes, one thing, question that was for consideration, whether these employees, teachers appointed in the AP study circle are entitled for UGC. That is the law well settled by the Honorable Court and Supreme Court. Those employees, in respect I said, those employees, those teachers, who have been working in any colleges, degree colleges, or colleges, aided colleges, affiliated to the universities are entitled for the UGC scale.
No, so Mr. You should have taken a plea that they have not been appointed against a vacant sanction post and they are a backdoor entrant. Nothing. You say that appointed on temporary basis, their services have been continued until further orders.
Since I'm here to confine to the pleadings only, but what is stated by the respondent in the counter by AP study circle.
Not
They are not appointed.
They are served for a lifetime, Mr.
They were not.
He is, one of them is retired.
Yes, they were not appointed either in your lordship are well aware the law letter by the Honorable Supreme Court. Uma Devi thereafter interpreting the Uma.
He has said Uma Devi can't be a license to exploit people.
True. That's
it's not, Mr. It's not your case that they are backdoor entrant. They have not been subjected to process of selection. It is not, please don't argue whatever is not
by Honorable Court in firearming judgment, it cannot be said as a backdoor. But even for limited purpose, limited tenure, the appointments were made through the selection committee.
No, Mr. You have advertised the post invited applications. Annexure page 1 is the notification. They have applied, and thereafter this. So it's not that they have not been screened and this thing, and since they were relatives of some members, so therefore they have been appointed. It's not nobody's case.
If I may liberty to pursue your lordship.
Of course, all times.
Yes. Thing is, that must be on record.
No, Mr. What we say is tentative always, right? Subject to what you argue. It's not that what we say is final. We are just saying that from perusal of your counter, there is no such stand. And we have said that it is pursuant to a notification, these people have applied and got in and served for a lifetime.
Supposed to be a conscience keeper of the bench for always. That's the fact is.
Yes.
Certain facts to be brought to your lordship. In 2011, they were terminated from the service. Questioning the termination of our order, my lord, they have filed a writ petition. The writ petition now, my lord, in case in writ petition number 34192 of 2011, questioning the termination order.
34192?
34192 of 2011. That writ petition was filed challenging the order of termination. Initially, there was a stay. Later, my lord, it was vacated. The termination has attained finality from 2011 onwards.
Attained finality means what happened to the writ petition?
Main writ petition is pending, my lord. That is.
Then how it has attained finality?
Since stay has been vacated, writ petition is pending. That is pending.
Then
there are other writ petition.
It has not attained finality. It is pending adjudication. Don't say.
Yes, it is still pending. That writ petition is still pending. That means
Yes.
Well, challenging, there is another writ petition, my lord, that is also pending before this another report. But writ petition number 28,809 of 2019, which was filed by them, extending the pay scale as given by UGC.
28,000?
28,809 of 2019, my lord.
809.
My lord, that was disposed on 27/1/2000.
Of 19.
19, my lord, 19, I'm sorry. 2019.
Yes.
That was disposed of. Just to consider the while disposing of the said writ petition, there was a direct.
When?
On 27/1/2022. Leaving it open to the petitioner to approach the respondent to consider representation. Whether the UGC scales are applicable or not, these things are left open to the government to consider. While that representation was disposed of, both the states on 6/4/2022. That is because since it was disorganized, Telangana representation was disposed on 6/4/2022. Andhra Pradesh was disposed on 26/6/2022 because it was this AP study circle is a combined.
What do you think disposed? The representation made by the states are involved.
Both the estates was disposed of.
Yes. Disposed of. Separate writ petition is filed. In writ petition number 39,120 of 2022. These all the writ petitions are still pending.
39,000?
39,120 of 2022. For comprehensive hearing, my lord, these matters may be clubbed together, subject to your lord. I go by your lordship say.
Has been listed for such a long time, you didn't never said. Only when called upon to reply, you are just like keeping it as a this thing weapon to seek adjournment, right?
It's not.
They have retired. Have mercy on them.
Millet.
Yes.
The question that falls for consideration according to me, Millet, before submitting before your lordship, whether they are entitled for declaration is one aspect. Second is whether they are entitled for pay scales of UGC. As per the UGC regulations, Millet, in accordance with the UGC regulations, state government kept on giving GOs after GOs from 1988. 88. Yes.
So, Mr.
Yes. Just I invite your lordship's kind attention. Whether these employees, while working in the said post, are entitled for the UGC scales. And GOMS 508, your lordship, my lend friend referred to GOMS 520 and GOMS 208 and GOMS 14. What these GOs have been issued in conformity with the UGC regulations. Well, just I invite your lordship's kind attention at page number 52, to whom these UGC scales are applicable. This AP study circle is not an educational institution. It's only a coaching center. Page number 52, your lordship may kindly see the coverage.
That you have told us. In the counter, you have disclosed what is AP study circle.
Paragraph 4 of the GO 508 at page number 52, your lordship may kindly. Coverage and applicability of this UGC. So this scale shall be applicable.
Page
number 52, my lord. GOMS, I am reading 5.
Coverage and applicability.
Yes, applicability. These scales shall be applicable to all the teachers in the universities and affiliated degree and postgraduate colleges, whether government or private aided colleges, and also to the physical education personnel and librarians in the universities and in the above head colleges who are trying to pay in the revised pay scales of 1976. My lord, I stop here only, my lord. This is what, as my friend said, it's not a college. Nor was the college affiliated to the university, nor was the college which adapt the academic curriculum prescribed by the universities. Therefore, what the university, UGC as well as the state government had clearly intended to apply to those employees working in those institutions. This is AP study circle only means to give a coaching. It is not even a college, degree college. It's a coaching center. They each evening for 2 hours, morning for 1 hour. It doesn't matter if it's a degree college. I will not repeat my that. Therefore, this class
will not apply.
Repeated in all this every year, there would be a revision of pay scales as per the UGC guidelines. For every year, when the UGC revises its guidelines, state governments are undertaking to issue GOs, making applicable to those employees of the institution. Likewise, GOMS 520, little while ago, I read it, my lord. GOMS 208 was given later with the same verbatim reproduction, and again GOMS 14 was given in 2014 with the same verbatim reduction. ultimately, nutshell, I would like to submit before my lordship is that these UGC scales are applicable to them. Since they were working in the AP study circle, it's a coaching center. What is the degree college? I may not much dilate on this issue, Milad. What is the college which is...
All of us understand what is a degree college.
Degree college has to give degree certificates, my lordships will have.
Because everybody, you have gone to degree college,
Yes,
right? Huh?
These coaching centers will not give degrees, my
That I understood.
They will. That's what
You need not tell us what is a degree college. Everybody present here understands.
Yes, that
Except the 5 persons who have done 5-year course and come join the profession.
Therefore, they are not entitled for UGC scale.
Right.
Cut short my arguments, I would like to cite one judgment of the Honorable Supreme Court, my lord. That's Elmo Devi judgment, my lord.
Upa Devi, well known.
Yes, it's well known,
2006,
my lord, judgment is...
Volume 4 SSC, page 1, para 53.
Relying on the Uma Devi judgment. Yes.
Para 53.
Oh, no, just for the... Yes, I are very... Our job becomes easy when your lordships are well aware of this. From paragraph 28...
Who can say, Mr. that he is not aware of Uma Devi's judgment? Each one of us has read it.
2006 judgment.
Everybody has read it.
Yes.
Distinction between illegal and irregular appointment, and that exercise of regularization has to be taken.
Before your lordship to establish the fact, my lord, they were not appointed in a sanctioned post.
This is different.
28. Para 28.
What is Uma Devi?
I may not much trouble your lordship.
Which para?
28, my lord.
You want to read, you can. This is different, not Uma Devi. This is 21 judgment. Read.
Yes, 21. In this matter, my lord, Uma Devi judgment referred to
yes, referred.
My lord, 28, I may read it.
Yes.
28, my lord. Thus, as per the law laid down by this court, in the aforesaid decision, part-time employees are not entitled to seek regularization, as they are not working against any sanctioned post, or there cannot be any permanent continuance of part-time temporary employees as yet. Part-time temporary employees in a government-run institution cannot claim parity in salary with regular employees of the government on the principles of equal pay for equal work. Paragraph 29. Applying the law laid down by this court, in the aforesaid decisions, the directions issued by the High Court in the input judgment and order, more particularly directions paragraph 22 to 23, are unsustainable and behind the power of the judicial review of the High Court in excess of the power under Article 2 of the Constitution, even otherwise.
Yes.
Even otherwise, my lord, it is required to be noted that in the present case, the Union of India / Department subsequently came out with the regularization policy dated 36/2014, which is absolutely in consonance with the law laid down by this court in the case of Uma Devi Supra, which does not apply to the part-time workers who do not work on the sanctioned post. As for the settled proposition of law, the state has government and nobody can claim the regulation as a matter of right, rehearse the regulation policy. Therefore, in the absence of any sanctioned post and considering the fact that the respondents were serving as a contingent and part-time Safai Karmacharis, even otherwise they were not entitled for the benefit for regulation under the regulation policy dated 36/2014. So we are of the opinion that even the directions contained in paragraph 23 for granting a minimum basic pay group D post from particular date to those who have completed 20 years of part-time daily wage service also is
Alright, so part-time employees are not entitled to benefit of regularization.
Supreme Court had said that there must have been a sanction of the one aspect, and the second that there must have been long length of time. Melody Lords from Uma Devi onwards, even from 1992, Paira Singh onwards, and daily workers case 1990. Melody, all these cases, Justice K. Ram, mere length of service without there being a sanctioned post does not entitle an employee who is incumbent of the unsanctioned post is not entitled for regulation. This all case laws, Milad, more than it's a law.
Thank you.
Much
Thank you. Anything else? Anything else? That only one page. All right. Yes, madam. Reserved for orders. Heard. Mark their presence. So 2005 appeal finally comes to an end.
That's it.
We also feel What about 72 to 75? Yes.
The houses were taken. So 90 houses were taken. And forcefully, they're given checks.
Let's,
Checks not done.
not that much.
Now those people are still no compensation, all their costs have displayed. That when they are not filing a Honorable Court passed order, they will come to Supreme Court, which said they have not taken a single action. But they give undertake, they have not taken single action, and they will be remanded so that.
No, let's,
Will you please give a list of dates? Sure. Okay.
Lordships kindly, my lords.
Submissions 1, 2, 3, 4. So we conclude it within 5-10 minutes.
Lordships.
You have argued already. But you are right under Article 300A has been infringed.
They did not upon the.
Lordships kindly, my lords.
Wait, nothing is, we are not dictating an order. Why are you so anxious? He is just trying to, senior counsel is trying to tell us what is the matter about. Yes.
My husband wants a date on that day, it will be taken because the last 4 or 5 occasions. It's coming at something like goal, it will take not more than 10 minutes of.
Yes, all right. All right.
Let's, in 3 writ petitions, my lords, 26 persons were given checks and they were withheld, my lords, for one or the other reason because of the claims were doubtful. Then, my lords, after that, my lords, on the last date of hearing, my lords, we have submitted a memo that, my lords, petitioners 1 to 15 are eligible and, my lords, we are ready to give them checks. My lords, today, my lords, I am having those checks, my lords, if the petitioners are willing. And my lords, we have 4 my lords, 3 of them are not eligible because they are underage. And for the
After 4 years, Mr., the amount due to them after, when did you dispossess them from the property?
Plus 2020 May, 2020 May, my lords.
20 May. So this amount of compensation has been determined in May 20.
So this is only with respect to R&R package, my lords, rehabilitation package.
So what happens to after 3 years and now almost 4 months?
My lords, we have said, my lords, that
that is of course open for them to be. We don't know.
The district collector will take a call, my lords, with respect to that.
Checks have come out of the strong. Disbursement, actually. But it was.
No, he is ready to hand over if you are.
We are ready with the checks, my lords, and
Let them, instruct and stand counsel on the court to instruct to go to time and date 26. They're going to.
very good. Yes, we'll sort it out, my lords. We are willing, my lords.
We are taking the track.
We'll sort.
I know what the government will do next time. One of the check.
No, but a good idea that acquire it, dispossess someone and deposit the amount in there or give. What did they do? Dispossess you and
They get the
check. Very good. Mr. You are a state government, right? Committing an offence under 138 of the Negotiable Instruments Act. Unique thing, Mr. Paul. First time we are coming across where the check issued by the on behalf of this thing is being dishonored.
That's 28 minutes. May I request? Meanwhile, minutes we'll try to sort it out.
First, last day I am shortly.
28 minutes. Because the next week, minutes 2 holidays. Minutes.
Already our board is showing 70 cases. This is only cases.
19th is an ideal day. 19th August, Saturday.
I am only asking for time, minutes, because there are 8 petitioners claim is to be adjudicated. We are looking at.
We are giving you weeks time only.
Between there are 2 holidays. Plus 10 checks are already.
The Supreme Court has not said that you grant time to them and this thing. Right? You cannot seek. Please do not violate the undertaking given to you by Supreme Court.
This is only for malus
Supposing if he files an application before Supreme Court and we can't grant, Mr. Why should you
precipitate the matter? The petitioners agree, almost all their claims are addressed, Malus. That is my submission. At 21st, Malus.
You seek instructions, Mr. from petitioners in the meanwhile that these people are ready with checks. They can
Let that person My learned friends say that in time and place, all the petition will go there.
You tell time and place. You have the checks ready, right? Why should you seek time then? They will appear.
Plus the concerned officer will communicate, my lords, I'll communicate with the council as well.
Morning, 10:30, they'll be at the judicial office.
They will celebrate some.
They'll celebrate Independence Day.
They'll be in the
Which
16th, my lords, office. I'll seek instructions and communicate with like
Revenue judicial office, debate, 14th morning, 10:30. Petitions will be there.
Mister, if you have checks ready, where is the hitch? If the checks from whatever place, Siddipet, I don't know, can come to Hyderabad, I mean, you can't hand it over to petitioners. Strange.
Checks will hand over, my lords. There are 8 other claims.
Petitioners will go there.
Very well.
You will hand, that's what senior counsel is saying, that you hand over the checks to without their involvement. Otherwise, the petitioners may question them that why did you hand over why did you accept checks? He doesn't want that. Why do you want to get in this thing?
I'm grateful.
On account, yes. Mark the presence. Learned. What's your GP or what, Mr.
GP, my lords. GP attached to Advocate General.
For?
Attached to Advocate General.
Submits that. How many checks?
My lords, 9, my lords.
9 checks.
Yes.
But all of them can't go, right? Which petitioners in where petition?
My person, I'm sorry, my lords, my person.
That checks in respect of 9 petitioners in this batch of writ petitions are ready and shall be handed over to the to such petitioners who attend the office of Revenue Divisional Officer Siddipet on 14/8/2023.
And insofar as petitioners 2, 6 and 11, they have already received, my lords, way back in 2019 and 20. We have the bank statement as well.
Which petition?
Petitioner
There are
2,
4
6 and
petitions.
2, 6 and 11.
Which petition, Mr.?
Which petition?
There are 4 petitions.
My lords, in WP 34209146 and 25664, my lords.
People are expecting to not go there.
I don't think that they will ever try to dupe you with the government.
9 people list is being given, only those.
Yes.
Plus in these
9 checks you hand over. What's the difficulty?
Very well.
It's their money, right? You don't have the power to retain it for a single moment. You should have said that tomorrow itself I will hand over. How far is Siddipet from this place? No, how far? From here, Hyderabad. He has got the checks here.
80 kilometers.
You should have volunteered that tomorrow itself, 2:30, I will hand over the checks.
Even
You are
if you are
saying
ready, my lords,
14/8
to
14/8 also you are tentative and looking at us whether. So
I
mean,
was only asking for a longer
Nothing.
date to the so that my lords we can
learn
send
it
other claims
also.
as well.
Yes, madam, what have you written? No. We are not deliberately putting the time, otherwise they will say that you didn't appear at 10:30 and came at 11 o'clock, right? So that's why we kept the whole day open. Mr. Learned Senior Counsel submits that the 9 petitioners, the names of whom has been supplied to Mr. So and so, supplied to, which shall be supplied to Mr. So and so, Learned Counsel assisting the Learned Senior Counsel, shall appear on 14/8/2023 in the office of RDO Siddipet on whatever Siddipet and collect the checks. Full stop. However, on account of paucity of time, the matter could not be taken up. What date? 19th August 23.
I request my lords, yeah.
76.
7 to 71. 7 to 71. I take the chance, but
70, 71, we have probably 3 weeks time is granted to someone.
Somebody made a mention in the morning.
Morning. This is what happens, Mr.
68 to 71 is a batch. So somebody made a mention in the morning and took time.
See, Mr. This is what I mean. I'm very uncomfortable in doing this at 10:30, but this is what I mean is the practical side of it. That you have been waiting for the whole day. Somebody, youngster may have been 10:30 took away without informing you. I'm really very wary with this sort of practice, but we are adopting because this is the practice of this court. This what happens. You realize the hard way now. Yes. What to do? Yes, madam. What has been done in his matter? To whom?
The council who appeared.
Petitioner.
The batch and we are reading 71.
No, 68 the council appearing for the appellant sought time. Avani Reddy.
Avani Reddy, Mr. You, at least you should have the courtesy. And they, when they ask, they say that we have informed. And they have no objection. You deal with Mr. Avani Reddy at your own level. Okay. No, sorry for the inconvenience caused to you. Yes. What is 76?
Yesterday's matter.
Oh. No, who is? It will come up tomorrow, right? We'll see. The council may not be there. Again, same thing will happen. He will say that I was there till 4:30. It was not called.